evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Harley Gale Anderson, in accordance with the law that I will provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of the system of justice. Before proceeding further, it will be helpful for you to understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you the evidence that they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. Now, after the evidence is presented, the attorneys will have an opportunity to make closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to this case. After the final instructions are given, the alternate jurors will be released, and you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you to not communicate with anyone, including your fellow jurors, about this case. So no communication includes no emailing, texting, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules, please notify the court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell him or her that you are on the jury trying the case and ask the person to stop. If he or she persists, leave that person at once and immediately report the matter to the court deputy, who will advise me. All right, all cell phones, computers, tablets, and other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in silent or vibrating mode. You may use these devices during your recess, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved. Do not take any photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure that your cell phone or your electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. You cannot have in the jury room any cell phones, computers, or electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. Now, the case must be tried by you on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. That applies whether you're in the courthouse, whether you're at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussion of any sort with friends or family members about the case or the people and places involved. So, do not even with the closest family members make any comments or have them make any comments or ask you questions about this trial. In the age of electronic communications, I want to stress again that just as you must not talk about the case face-to-face, you must not talk about the case by using any electronic device. You must not use phones, computers, or any other electronic devices to communicate. And I know that's about the 5th time I've told you that, but that's the way they ask us to do it. So do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for any advice by any means at all, including posting information on an internet website, chat room, or blog. All right, what are the reasons for these rules? The rules are imposed because jurors must decide the case without distraction and only on the evidence presented here in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or to challenge the accuracy of what you found. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect for that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail or paying a fine or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, and what a witness might have said had he or she been permitted to answer. Now, during the trial, it may be necessary to confer with the attorneys out of the hearing of the jury to discuss matters that require consideration by me alone. It is impossible to predict when a conference may be required and how long it will last. When such conferences occur, they will be conducted as to consume as little of your time as necessary for a fair and orderly trial of this case. So let me explain. You saw a little bit of that yesterday where I will use the white noise. I will bring the attorneys up there, and if it's something that we believe we could resolve within a few minutes or so, we will do that. However, I do want to advise you that there are some times where it may take longer. In that instance, I will have the deputy take you back to the jury room to recess so you can be comfortable while we are addressing that matter. All right, so what you have there in your hands is a notebook with some paper, and either have a pencil or a pen. I do have an instruction regarding note-taking. Okay, so if you'd listen to that, please. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with that notebook each time that you come in here. It will be there on the chair. And does everyone have a pen or a pencil that is in working order? Double check that. If not, we will certainly get you one. However, you should not take them with you from the courtroom. So each time that we recess, please just leave the notebook on your chair. During recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations in this matter, the court deputy will deliver the notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in the note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take the notes, you should rely on the memory of the evidence, and you should not unduly be influenced of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. All right, State, you may proceed.
Good morning. On January 19th, 2025, the Cocoa Beach Police Department received several calls, all of which were regarding a large open house party involving minors that was taking place at 44 Country Club Road in Cocoa Beach. And later in the evening, he drove by one final time just to make sure that everyone who had been in attendance at that party had dispersed. And that was when he saw CR hunched over in the front yard of that residence, in the grass, vomiting and spitting. When Corporal Brown began speaking with the minor child, he noticed that he was slurring his words and he was not able to answer the questions that Corporal Brown was trying to ask him. This caused Corporal Brown to become concerned for the child's safety and his well-being. So Corporal Brown contacted the local fire departments and requested that they send medics who could assess the minor child and possibly assist him if he was in need of medical attention. Corporal Brown was also able to contact the minor child's mother to inform her of the situation and what was going on. During this trial, you're also going to hear from one of the emergency medical technicians, or EMTs, who works with Brevard County Fire Rescue. His name is Andrew Rock, and he is going to tell you about his observations of the minor child and what his involvement was in this case. After the child was assessed by the medics and the fire department, and after Corporal Brown spoke with the child's mother, the decision was made that Corporal Brown was going to transport the minor child back to the police station where his mother would meet them, and she would then take care of him from there and determine what should be done with him. You're going to hear from both Corporal Brown and Andrew Rock about Corporal Brown then asked one of the EMTs, two of the EMTs, one of which was Andrew Rock, to assist him in moving the child from the front yard of 44 Country Club Road into Corporal Brown's patrol car so that the transport could take place. And you're going to hear from both Corporal Brown and Andrew Rock about how when they were in the process of moving the child into Corporal Brown's police car, they were interrupted and approached by the defendant, Ms. Carly Anderson. You're going to hear about how Ms. Anderson approached the EMTs, demanding to know why the child was being placed into a machine. When the EMTs told Ms. Anderson that they could not provide her with any information, and that quite frankly it was none of her business what was going on, and that she needed to go away, Ms. Anderson became angry, belligerent, and began yelling at the EMTs. Corporal Brown, who was still in the process of trying to place the minor child into the back of his car, heard this commotion and walked toward them in an attempt to figure out what was going on and to make sure that the situation was not going to escalate any further. Ms. Anderson then began yelling at Corporal Brown. You're going to hear from Corporal Brown about the interaction that he had with Ms. Anderson. He's going to tell you what he observed about Ms. Anderson. You're also going to see the interaction between Corporal Brown and Ms. Anderson for yourselves, as this interaction was captured on Corporal Brown's body-worn camera. When watching that video, it is going to become clear to you that Ms. Anderson was intoxicated. Corporal Brown is going to explain to you what impact this interaction with Ms. Anderson had on his ability to care for the minor child that was in the back of his patrol car at the time, that this hindered his ability to care for that sick and impaired child and delayed him in being able to transport the child to the station where he was to be reunited with his mother so that she could care for him. You see, this case is not about what Ms. Anderson was saying or the content of that speech. Rather, this case is about what effect Ms. Anderson's outburst and belligerent behavior had, and that it hindered Corporal Brown in the performance of his legal duties, when at that time he was acting as a caretaker for this minor child who was sick. The state intends to prove to you beyond a reasonable doubt that Ms. Anderson is guilty of disorderly intoxication, as she was drunk and endangered the safety of the minor child who was under the care of Corporal Brown that evening. The state also intends to prove to you beyond a reasonable doubt that Ms. Anderson is guilty of resisting an officer without violence or obstructing Corporal Brown while Corporal Brown was engaged in a lawful execution of a legal duty. At the conclusion of this trial, when you have seen and heard all of the evidence for yourselves, the state will then ask you to return a verdict of guilty for both counts. Thank you.
All right, in defense, you may make an opening statement if you wish.
Yes, Your Honor. Morning, ladies and gentlemen, counsel. So, as you know, this entire event revolves out of a high school party at Miss Anderson's friend's house that got out of control. And there's nothing new about kids having high school parties. They did it when I was in high school. They still do it. What's new now is digital media. And they get on something called Snapchat. And instead of just telling a few friends, hey, we're going to have a little get-together, come on over to my mom's house. It goes on Snapchat, and kids pick it up all over the place and show up from everywhere, and it gets out of control real quick. So that's what happened, and this happened on January 19th of this year, which was the night before Martin Luther King Day. Martin Luther King Day was a school holiday, and this was a Sunday night. Okay, so the principal, Ms. Hill Brodigan, friends with Carly Anderson, called her up and said, hey, let's go out and have a drink. They live right down the street from each other. And Ms. Hill Brodigan picked her up, brought her out to a local establishment in Cocoa Beach, just a few miles away from their house on Minuteman Causeway. And they both live on Minuteman Causeway. And they proceeded to have adult beverages, and were in the process of thinking about ordering some wings and having a night out. At that moment, somebody from the Cocoa Beach Police Department called Miss Hill Brodigan and said, there's a party that's out of control at your house, and you need to come home right now and disperse it. extinguish it, fix it. So Miss Anderson gets informed of this and says, okay, I'll go with you. Big mistake on her part. That's where things start to go wrong for her. No good deed goes unpunished. So she drives, they drive back to the house. They may have made a stop someplace else. Within a few minutes, they're both back at the house. Miss Hill-Brodigan goes right by Miss Anderson's house, doesn't give her an opportunity to get out of the car. And there's the remnants of an out-of-control party is going on. They proceed to work on telling the kids to go home. This house that this party is at backs up onto the golf course. So I'm imagining kids were running around on the golf course and making a nuisance to all the neighbors. So she was there for some time and never provided any alcohol to any minors, never had a drink with any minors, never knew anything about this party until the police called and said, you need to come back here. So I'm thinking it's about an hour after they returned, and that's when you're going to see a body cam clip. It lasts about 3 minutes, so don't worry, it's not going to be like grueling long or anything. And it shows Corporal Brown, who found a young man in the front yard. I think he said vomiting and shivering. Well, this was towards the end of January, and I think this kid didn't have a jacket on, and it was probably about high 50s or 60 degrees. So he was cold, and probably had too much to drink and sitting in the grass in front of Hill-Brodigan's residence. So Corporal Brown calls the ambulance, which probably is an overreaction, but that's his choice. In the abundance of caution, call an ambulance on a drunk kid who's puking, that's okay. He calls EMT, the fire department shows up, they evaluate the kid, who is CR, that's what state has told you, and that's his name for this trial today. They evaluate him, and he apparently is fine. And Corporal Brown asks him some questions. It's his mom's phone number. He calls the mom, and I think you're going to hear testimony that the mom was in Orlando or Sanford, but would come over to the Cocoa Beach Police Department to pick him up. And I'm going to ask Corporal Brown about that. And you just watch the video carefully. They pick up the kid. They go, 1, 2, 3, come on. You'll hear his name. 1, 2, 3, come on, let's get up. And Corporal Brown has agreed, for some reason, to put him in the back of this police car and take him to the Cocoa Beach Police Department where he can meet his mother. Instead of, knocking on the door of the residence and saying, hey, you need to take care of this kid until his mom gets here, he's putting him in the back of a police car. And about 99% of the people that get put in the back of a police car are under arrest. So the kid is in the police car. No more emergency services being rendered on him. He's actually in and sitting down. And then you see Mrs. Anderson come out of the darkness. And yes, she was intoxicated at that point in time. She comes out of the darkness and goes, what are you doing? And the paramedic, maybe it's Mr. Roque, maybe it's one of the other ones, basically says none of your business, and then he walks away from him. That's it. Kate is already in the police car, and then Miss Anderson, who is a school teacher, is very familiar with Corporal Brown. He was a school resource officer at her school, which is also right down the street from where all this took place. And she knew him very well. They had spent many hours together during fire drills and in recess, talking to each other, and really had become friends. So she's familiar with Corporal Brown and considers him another professional in the area that's trying to take care of this kid. And she starts talking to him. She says, "What's wrong with him? Why won't they tell me what's going on with this kid? You guys are out of control." And she has a moment. And Corporal Brown is very calm most of the time. And she uses the word, "I'm concerned about this child. I'm concerned about a child being put into a machine." She says, "I've been at this party," and what she was saying is, "I've been here for an hour since the police told us to come back and disperse the party." And she basically has some conversation with him. She doesn't threaten him. She doesn't touch him. At one point in time, he flips the switch, so to speak, and starts yelling at her. He goes from calm to absolutely yelling at her. And he says, "I'll tell you what's going on. There was 200 kids here drinking with you and your boss, and get out of my face." And he turns and she says, "That's on your body cam," and walks away. And that's it. That's the whole case. So he got it wrong. She wasn't there drinking with juveniles or throwing a party. Not in any way. And I don't know what duty she obstructed him in doing, what legal duty or legal process. Kid was in the car. He had a consensual citizen police encounter with her. And although it's probably a bad idea to yell at a police officer, it's not illegal. It is protected under the First Amendment, our right to free speech. And we can say what we want to, as long as it doesn't, rise to the level of committing a crime. You can't sit in a theater full of people and yell "fire" when there is no fire and have people trample themselves on the way out. That's the common example of when free speech is a crime. So what she did is have a conversation with him. He yelled at her and said, "Get out of my face," and that was the end of it. And he walked around and got in the car and drove CR to the police department. CR was never endangered by Miss Anderson, and Corporal Brown was never impeded in any way. He chose to talk to her, and they knew each other well. It's not like they were strangers, and they engaged in a conversation which he ended at his choice when he was ready. You'll also hear that Corporal Brown was a law enforcement officer working for Cocoa Beach Police Department that night. I assume he still works there. And he didn't arrest Mrs. Anderson for anything. He didn't arrest her for disorderly intoxication. He didn't arrest her for resisting without violence. Had he observed those crimes, he certainly could have called another officer, said, "CR, you're going to have to wait a minute while I get another officer here to put Mrs. Anderson in the back of a police car." But notably, he didn't observe those crimes. He didn't choose to make any arrest. So you will hear more details, and I think we'll be able to conclude this case today, probably. So just pay attention, watch the video, watch for what I was suggesting, CR is in the car before Miss Anderson appears out of the darkness. And that's when there's no endangerment of CR by her at that point in time, because they already did whatever they're going to do to him. And even if she had have got up to him before they put him in the car, he was never in danger of anything except for his own excessive drinking as a minor.
All right, thank you. Deputy, can you approach for a moment, please? All right, state, you may proceed with your first witness.
The state calls Andrew Rock.
Swear affirm the testimony you shall give will be the truth, the whole truth, nothing but the truth, so help you God.
Please watch your step, and as you'll note, you don't want to push back. You can move the chair in front of the mic.
Good morning.
Morning.
Could you please state your name and spell your last name for the record?
My name is Andrew Rock, R-O-C-Q-U-E.
Where do you work?
I work for Brevard County Fire Rescue.
How long have you worked there?
2 years.
What is your position with Brevard County Rescue?
Firefighter EMT.
And is Brevard County Fire Rescue sometimes called BCFR?
Yes.
I want to direct your attention to January 19th of this year. Were you working that evening?
Yes, ma'am.
What station were you working at?
Station 51,
Where's that?
Cocoa Beach.
Around 11 p.m., 11:19 p.m., were you dispatched to a call?
Yes, ma'am.
What was that call in reference to?
We were dispatched to a sick person.
When you say we, was someone else with you?
My lieutenant.
What was the location of the call?
It was in Cocoa Beach, 44 Country Club Road.
And what kind of area is that?
It's a neighborhood.
When you got to your dispatch to the call, did you arrive at Country Club Road?
Yes, ma'am.
What did you observe once you got there?
When we got on scene, the engine was already on scene. We saw
I'm going to
kids.
stop really quick. When you say the engine, what's the engine?
It's a fire truck. It pumps the water.
Okay. And what kind of vehicle were you in?
I was in the rescue, which is an ambulance.
Okay. So the engine's there, and the ambulance comes. Okay.
Yes.
And then what did you observe?
When we got on scene, we saw kids all around. They were walking through the yard. We saw the one minor that we were giving attention to. He was sitting in the grass near the road with the officer, and then Engine 51 was there on scene getting vitals and talking to the officer and the minor.
Okay. When you said the engine was getting vitals, are those other firefighter EMTs?
Yes, ma'am.
Okay. And when they're getting vitals, what kind of things are you looking for?
We're just getting the basic blood pressure, pulse, SpO2 reading,
What's SpO2?
just their blood oxygen level.
Okay. So the juvenile was assessed.
The juvenile was assessed. He was answering our questions correctly, and his vitals were great.
Okay. Based on that, what happened next?
Based on that, we determined that he did not need to be transported to the hospital. There was no need for him. He didn't need emergency medical care.
Okay. So once it's determined he doesn't need to be transported, what was the next step in your process?
Well, the next step in our process, since he is a minor, we did need to call his mother because he cannot refuse on his own.
Refuse, what do you mean by refuse?
He cannot refuse to be transported to the hospital. He
Okay.
can't sign a piece of paper saying that he does not want to go to the hospital.
Okay,
Or
because he's a
our
kid.
computer, yes, because he's a kid.
Okay, so somebody
So-
called the mom.
So the police officer called his mom, said that we checked him out and that he was good. He didn't need to go to the hospital. He was answering our questions. And then we had the police officer witness us signing the refusal, because obviously the minor couldn't sign, so we had the police officer witness it.
Is that like a form?
Yeah, it's a form. We have it on our computer and we just sign it electronically.
Okay. So that form gets signed by the Cocoa Beach officer,
Yes,
and the child's not going to be transported?
yes.
Okay,
Because mother was not present.
okay. So after you got the form, then what happens?
After we got the form, Engine 51 got the refusal form. We typed that up as a cancel on our part. The engine cancels us on scene.
What does that mean?
Basically, we don't have to do any patient care, and we're not loading them up into our ambulance
Okay,
and taking them to the hospital.
okay.
So it was.
So your call's kind of,
Yeah, it was
say
a
canceled.
PD matter after that.
okay. Okay. So the call gets canceled, and then what happens?
When the call gets canceled, we basically pack up and we leave once we confirm with the officer and make sure everything's good on scene, that they don't need our attention anymore.
Okay.
Then we'll pack up and leave.
Did Corporal Brown, did you pack up and leave?
No, Corporal Brown asked us to help get the minor into the car, into
Whose
his car, his cop car.
Okay. Asked you and your lieutenant?
Yes,
Okay. Did you help with that?
we did. My lieutenant was the one standing beside the minor and helping Officer Brown put the kid into the car, help him walk him to the car. I was just walking behind. And at that moment, when we were trying to put the minor into the car,
Just,
Uh,
sorry, I want to really quick. How would you describe the condition of the child?
he was with it, but it was cold, so he was asking for a blanket.
Okay. Okay. Okay, so then he's getting put in the car. Sorry, I interrupted you.
We were putting him in the car, and that's when a lady came up and asked what we were doing.
Came up to the car.
She was a couple feet back, but yeah,
Did you know who she was?
no, had no idea.
Was she saying anything?
She just was wondering what we were doing, and we told her, this is none of your business, please go away.
After you said that, what, did she respond at all?
Yeah, she was very angry at our response. She didn't like that we told her to go away. And she also was like, please don't put that kid into that machine.
Okay, so she comes up, you tell her to go away, and then what happened? Did you?
She did not go away. She kept yelling at us.
Okay. And what did you do?
We kept trying to be very nice and telling her, please go away. This is none of your business. We can't tell you anything under HIPAA. This is a private medical.
Okay. Then did you keep engaging with her, or?
No, she eventually steered her attention to the officer because she didn't like how we were talking to her. So she got angry with us and then started to talk to Officer Brown and was like, do you hear how they're talking to me? And wanted him to make us cooperate.
Okay. And did you, after that, did you guys stick around, or what happened?
We hung around for a minute or two, and then after her attention was focused on Officer Brown, we kind of looked at Officer Brown and was like, okay, this is yours, we're gonna get out of here. And we kind of just did that and left.
Got in
It was
the
not our
ambulance
scene
and left?
anymore. Yeah.
Okay. May I confer with counsel?
Yes, you may.
Nothing further from the state.
All right, Vince?
Good morning, Mr. Rock, right?
Yes.
Okay. So, when Mrs. Anderson first contacted you, the juvenile was already in the back of the police car, wasn't he?
We were just about to get him into the police car.
Have you reviewed the video in this case?
I saw the video. I saw it once. And that's because it was posted all over social media.
Yeah. You saw it once a while ago?
Yeah,
Okay. Did you see yourself on the video at all?
I did see myself on the video.
Okay. And you guys determined that the minor, CR, was okay, right?
Yes, sir.
And in fact, Mrs. Anderson didn't do anything to endanger him, did she?
No, she did not.
Okay. And when she was talking to you, she didn't threaten you in any way, did she?
No, she did not.
Okay. And you say that did you personally have a conversation with her, or was it your supervisor?
No, I did not say a word. It was my supervisor that told her to go away.
And that was it, right?
Yeah, that was it.
There was no discussion about this is a private matter with HIPAA and all that, right?
We don't go out and say it's HIPAA. We just say it's a private matter. Please go away.
Right. Okay. And that was the end of it for you guys, right?
Yes, yes.
Did you see Mrs. Anderson commit any crime?
No, sir.
I have no other questions.
All right. State, any redirect?
When the decision is made not to transport someone, does that mean they're totally fine and healthy?
We can't diagnose. We can't be sure that nothing is wrong. That's the hospital. They have to do blood cultures. But we do tell them, hey, we would suggest transport and everything. And then they have their free will to decide if they are able to, and they are able to answer our questions, which means they are in the state of mind to make that decision.
Could someone be considered sick but not meet the requirements that you have to
Yes, ma'am.
transport them?
Yes, ma'am.
Okay. And then when the ambulance left, was anything still going on? Was everything quiet and peaceful?
No. The lady was still arguing with the officer.
Okay. No further questions.
Okay. Any recross? Spence?
Just 1 second, Your Honor.
Sure.
Just very briefly. Were you aware of where this kid's mother was, by any chance?
We got told that she was in Orlando.
Okay. And you were under the impression that she was going to drive from somewhere in Orlando to go to the police department to pick up intoxicated CR?
Yes, sir.
Is that what's going on?
Yes, sir.
Okay, I have no other questions. Thank you.
All right. All right, so you may step down. Subject to recall? State?
Yes.
Okay. All right, State, you can call your next witness.
The state will call Demetrius Brown.
Also, please note not to push the chair back too far. Thank you. You may proceed when ready.
Thank you, Judge. Good morning.
Morning.
Can you please state your first and last name and spell your last name for the record?
Demetrius Brown, last name spelled B-R-O-W-N.
Where do you work?
The City of Cocoa Beach Police Department.
How long have you been employed by the Cocoa Beach Police Department?
6 years.
Can you please explain, just in a broad overview, the experience and training that you had to have in order to become a police officer?
I had to take a 770-hour course mandated by Florida Department of Law Enforcement. After completing that, I completed a series of training at my police department with a certified training officer before I became a sole officer on my own.
And what do your duties entail now with your job?
My current role is police corporal. I am a mid-level supervisor where I supervise a shift of 4 people.
What shift do you typically work?
I am currently assigned to our day shift.
What shift were you assigned to in January of
I,
this year?
I was on night shift,
Night shift? What are those hours typically?
6 p.m. to 6 a.m.
Directing your attention back to the night of January 19th, earlier this year, were you working that evening?
Yes,
And what were your duties that evening at work?
I was assigned as patrol corporal, so my duties were to supervise the shift, make sure officers are conducting per agency policy.
That evening, did you go to 44 Country Club Road in Cocoa Beach?
Yes.
Why?
We responded initially to a noise complaint.
What was that noise? Just give us kind of a big, broad background of what was going on that evening.
The call was dispatched regarding loud music, people running through neighbors' yards, and smoking marijuana.
And how many times did you respond to that address throughout the course of that evening?
I believe approximately 3 times.
And why were you, I guess, going and leaving and coming back?
The first time I responded after 2 other officers had already responded, and they made contact with someone and advised them of the complaint of the noise. So we left after that. And then we received another call, which we ended up going back out there a second time.
And how would you describe that location?
There were a lot of vehicles along the roadside in front of the house and further down in front of other residences as well.
Later in the night, after approximately 11 p.m., did you return to the house again?
Yes.
And why did you do that?
I drove down there to make sure that everyone had left and that there weren't still, people hanging around in the yard and things like that.
And when you drove by that time, a little after 11 p.m., what did you observe?
I saw 3 juveniles in the grass. There was one sitting who appeared to look ill.
And what were the other 2 juveniles doing?
They were standing there next to him.
Did you get out and interact with them?
I did.
And what was happening with the minor child at the time the one who was in the grass?
So as I walked up, I could tell his face was flushed. He was vomiting in the grass. So those signs to me that something was wrong.
Did you attempt to speak with him?
I did, yes.
And how did that go?
He was unresponsive to me.
What did you do after encountering him?
I tried to find out his name and things like that from the people that were standing there with him. And then I eventually called our fire department and paramedics to come check on him.
And what was it that caused you to be concerned enough that you called Brevard County Fire Rescue?
Because I knew that there was alcohol involved at the residence, I assumed that he was probably under the influence and that he needed some type of medical attention. I wanted to make sure that nothing serious was happening with him.
And what happened after Brevard County Fire Rescue arrived?
Between them and our fire department, they checked his vitals. They made sure that he was okay for the most part, and they were able to actually get his parents' phone number, so I called his mom while they were doing that.
So when you were able to contact his mother on the phone, what was the end result of that?
She was going to come pick him up from our police department, so I explained to his mom that I was going to drive him there and sit with him until she arrived.
So you were going to be supervising him and caring for him until she could get there herself?
Yes.
And after this decision was made, after you spoke with the juvenile's mother, what did you do?
I asked one of the paramedics to assist me with getting him to my patrol vehicle.
Did they help you?
Yes.
And while you were in the process of getting the juvenile into your patrol car, what happened next?
After putting him in, I heard a commotion behind me, and as I turned around to walk back towards the paramedics, I observed the person who was talking or yelling towards them.
And who was that person?
That would be Miss Carly Anderson.
How do you know Miss Anderson? Or how did you recognize her that night?
I recognized her because I've worked at the elementary school before a few times, and I recognized her as one of the staff there.
Do you see Ms. Anderson in the courtroom today?
I do.
Can you please point to her and identify an article of clothing that she's wearing?
She's wearing a black shirt with a necklace.
Please let the record reflect that the witness has identified the defendant.
So reflected.
Why did you walk towards the commotion that you heard?
Because I didn't know what was going on. I didn't know if someone needed help or if there was someone else in danger. So I went to see what the issue was to try to resolve it.
And when we say commotion, can you describe what that was?
It was loud yelling as if someone was upset.
When you walked back there, did you then interact with Ms. Anderson?
Yes.
When you approached her and the EMTs, were you wearing your uniform?
Yes, I was.
Is that the uniform that you're wearing today?
Yes.
Can you please describe your interaction with Ms. Anderson?
She seemed upset. I could tell that she had been drinking because I could smell the odor coming from her breath. And it was just a different demeanor than what I'm normally used to seeing her in.
And how would you describe the demeanor with which she was speaking?
That night, I would say she was clearly visibly upset. Yeah.
Was she speaking at a normal volume?
No, she was loud.
Was this interaction with Ms. Anderson recorded?
Yes,
How was it recorded?
on my agency body camera.
You may.
Corporal Brown, I'm showing you what has been marked as State's Exhibit A for identification purposes. Do you recognize that?
Yes,
And how do you recognize it?
my signature or my initials are dated there.
And what is that?
That is the USB drive with my body camera video on it.
And is that a fair and accurate depiction or representation of your body camera recording from the night in question?
Yes.
At this time, the state would ask to move State's Exhibit A into evidence as State's Exhibit 1.
All right, any objection from the defense?
No objection, Your Honor.
All right, it'll be moved in as State's Exhibit 1. All right, yes, you may do that. Remember Tony. Okay. Do you want the lights lowered, or do you want it to?
Yes, please.
still or no?
What the fuck is wrong with him?
What?
I'm concerned about a child that's being put into a machine, into one of these vehicles, and it's none of my fucking business. You say something to them.
Well, they can't.
You tell Cocoa Beach has gone fucking mad and nasty.
They don't work for us. That's Brevard County Fire Rescue.
Well, you know, I'm a teacher. Who the fuck did you put in who got in that car?
It's okay, but they just like they can.
I was here hanging out at this party. I mean, what the fuck? What's wrong with them?
Okay.
You guys gotta act better.
Do you want the truth? There was like 200 kids here
I've already known.
drinking, okay? And you're drunk as well.
I'm not drunk.
Yes, you are. I smell
Oh, you smell it.
it. Yes.
All right, let's do it.
No,
Do
we're
a
not
test.
going to do that,
But
but
you need to do a test.
purpose.
But I'm saying, but I'm concerned.
And you're intoxicated too.
Oh, who cares? So I look at your car and my view or call my
Because he's 17 and he was here drinking at a party.
Why are you yelling at me?
Because you're yelling. You're here with your boss having a party with 200 kids who are drinking. Get out of my face. Now.
That's on your camera.
It is.
Were you at 44 Country Club Road when Miss Hilbrodigan and Miss Anderson had initially appeared at the party?
Yes.
How much time approximately had passed between when they were initially seen at the party and the interaction that we just watched?
I would say probably approximately about 15 minutes.
At the time of your interaction with Ms. Anderson, were you engaged in the lawful execution of a legal duty?
Yes.
How would you characterize the duty that you were engaged in at that time?
I had a duty to care for the juvenile and make sure that he was safe. So I was in the process of doing that.
What effect did your interaction with Ms. Anderson have on that duty?
It took my attention away from the juvenile who was placed in the back of my car, who I could not see because I was interacting with her.
And why did you, when you heard her yelling at the EMTs, why did you feel the need to go back and investigate what was going on?
Because disturbances can lead to anything, you know, especially if I don't know what's going on. So it's a safety issue, and I also wanted to make sure that the paramedics were also okay.
On the video, we heard you eventually get frustrated with Miss Anderson and tell her to go away. Why did you do that?
Because after trying to give her some explanation without giving too much information, I realized that I couldn't get through to her, couldn't reason with her, so I just decided to end the conversation.
Why did you feel like you could not reason with
Because usually someone who is impaired, it is harder for you to talk with them and get an understanding because of the intoxication level.
In your experience as a law enforcement officer and even in your own personal experience, have you encountered people who are drunk?
Yes.
And what do you typically observe about people who are drunk?
Everyone's different, usually on the impairment, but slurred speech, bloodshot eyes, flushed face, things like that, that would indicate impairment.
And based on your observations of the minor child, what were your concerns regarding his level of intoxication?
He was impaired, and I didn't believe he would be able to take care of himself without an adult.
What concerns did you have about leaving him in the back of your patrol car alone, unsupervised?
Alcohol affects everyone differently, especially for someone who's a minor. He would have had a medical episode back there while I was talking with Miss Anderson. Wouldn't have been able to know because I wasn't in the vehicle with him.
And did your interaction with Miss Anderson being forced to kind of ameliorate that situation, did that prevent you from transporting the juvenile, or I guess delay you from transporting the juvenile?
Yes, it did.
Why did you not make an arrest of Miss Anderson at that time?
I was the only officer there, and the child was more of my priority concern than making an arrest at that time.
So you would not have been able to arrest her since the juvenile was already in your vehicle?
Yes.
Did this encounter occur in Brevard County?
Yes, it did.
May I confer with counsel?
You may.
No further questions at this time, Judge.
All right. Events, you can cross-examine.
Morning.
So, your engagement with Mrs. Anderson, it's just what we saw here. It took about 2 minutes,
Yes, sir.
okay? And did you feel that that 2 minutes endangered the welfare of the child in the back of your car?
Yes.
You do?
Yes.
When you got back in the car, was he the same as he was when you left him there?
Yes.
Was the door open while you were talking to her?
No.
You'd shut the door,
Yes.
okay? And how long did it take you to get to the police department?
Roughly 2 minutes.
2 or 3 minutes?
Yes, sir.
And how long did it take for his mother to get to the police department?
I believe about an hour.
Okay. And was the child endangered because of her length of time in getting there?
No,
Okay. And how was that?
because I was sitting with him the entire time.
And what was he doing?
He was sitting in the back seat. He vomited again.
In your police car?
Yes.
Did you take him into the police department?
No, we sat in the car downstairs.
Did you talk to him?
I did.
Asking him questions about the party?
No,
What did you talk to him about?
I wouldn't be able to remember that.
Okay. So you felt that it was your legal duty to take this child to the police department?
Yes.
Could you have just knocked on the door of the Hill Brodigan residence and say, this guy doesn't need to go to the hospital, but somebody needs to watch him until his mother picks him up?
No,
Why is that?
because I already spoke with his mom, and that was the preferred choice she wanted.
Did you give her any other choices?
No?
Okay. So that was really your choice.
Not really.
And how is it your legal duty to transport a child who's not under arrest in the back of your police car anywhere?
My legal duty to care for him, as there was not an adult who could legally care for him, He was 17.
Okay. How often do you put people in the back of your police car that are not under arrest?
Quite often.
Often?
Yes.
Okay. Adults and juveniles?
Yes.
Okay. And you know Mrs. Anderson very well, don't you?
I wouldn't. Yes. I'm familiar with her. Had conversation.
Okay. And you were the school resource officer for a while where she was teaching?
No, I just substituted
You were
for a
what?
little. I substituted. I just assisted for a few days.
Okay, so it wasn't your assignment, but you worked in that role sometimes.
Yes.
And did you have conversations with her?
Yes.
And did you view her as a upstanding citizen, a nice person?
Yes.
Okay. And in this particular occasion, you knew she was upset, right?
Yes.
Okay. And the conversation that you had with her that we just saw in the video was with your consent, wasn't it?
Yes.
And she didn't threaten you or tell you not to do anything, right?
Correct.
And at one point in time, you became loud.
Yes.
And was that because your emotions were widely swinging?
No.
Okay. You went from calm and quiet to suddenly full on yelling at her.
Yes.
And you told her to get out of your face.
That is correct.
And she did that, right?
I walked away.
You walked away. And you could have ended the conversation with her at any moment, couldn't you?
Yes.
Did you see her commit any crime during that interaction with you?
Yes.
By talking to you?
No.
What was the crime you saw?
Well, there is the 25-foot buffer between first responders.
25-foot rule, is that what you said?
Yes.
Okay. What rule is that? Maybe you could tell me about that.
Objection.
All right, you may approach. it's overruled, and Mr. Weaver, you may continue.
Okay, so you can explain your answer if you remember the question.
The HALO law, which was signed by Governor DeSantis, creates a 25-foot buffer between first responders who are actively engaged in an incident.
Okay. Did you see you saw the video that just played, right?
Yes,
Would you agree with me that the child was in the back of the car by the time Mrs. Anderson walked up on the scene?
yes,
And the child had already been evaluated, and they determined that no medical need was to be served by taking him to the hospital.
yes.
And that's when you decided you were going to put him in your car and call his mother.
Well, I had already called his mother, but
What's that?
I had already called his mother before putting him in the car.
And your position is that the 1 minute and 30 seconds or 2 minutes of Mrs. Anderson, someone you know well, asking you what's going on, that endangered this child's life?
Yes.
Okay. All right, thank you. I have no other questions.
All right. State, do you have any redirect?
Just briefly, Judge.
Okay.
Do part of your duties as a law enforcement officer, aside from making arrests for crimes and the things that we typically see police officers do on television shows and all of that, do part of your duties include being a community caretaker?
Yes.
What does that mean?
The best way I can explain that is for like Marchmans and bakers. So someone who is impaired to the point where they can't care for themselves, we have the legal responsibility to take them to a preferred facility to where they can get help and get assistance.
And does part of that duty include ensuring the safety of citizens, people that are part of the public?
Yes.
On cross-examination, you described, or you agreed with defense counsel that the conversation that you were having with Ms. Anderson was consensual. What is your, I guess, reasoning behind that?
So, like I said, initially it was the disturbance that I turned around and approached her in regards to. I could tell she had concerns about the juvenile, and my goal was to try to at least answer a question and give her a brief explanation before leaving the scene and taking the juvenile back to the police department. That was my goal.
So when you say it was consensual, you weren't talking to her against your will.
Correct.
Would it have been appropriate for you to just get in your car and leave the scene with the juvenile without first investigating what the commotion was and the yelling that you had overheard with the EMTs?
No.
Why?
Because if something were to happen, or if something was going to happen, and I just left, it would look bad.
You also stated that on cross-examination that the minor child, CR, was still vomiting in your car?
Yes.
And earlier when you described being concerned about a medical episode potentially happening while you were away, what kind of medical episode were you worried could potentially occur?
Seizures could happen. That happens a lot with alcohol abuse or anything other.
Did you have any concerns regarding the fact that he had still been vomiting throughout the time that you were with him?
Yes.
What were those concerns?
It is very easy for someone to choke on their own vomit and stop breathing.
So although, as you testified, when you ultimately got back to the patrol car, the minor child appeared to be okay, although he vomited later, there were concerns that in the time that you were away, something could have happened where you would not have been able to supervise it or assist him.
Yes.
No further questions.
All right. Any recross?
Just briefly, Judge. Would you agree with me that what Ms. Anderson, her interaction with you is just entirely verbal?
Yes.
Okay. And have you discussed this case with anybody else from your department?
Yes.
Okay. And what did those discussions entail?
Objection.
Your objection?
Relevance.
Okay. You may approach. All right, so it's overruled as to relevance and sustained beyond the scope.
Okay. Have you discussed the case with any of the members of the state attorney's office?
May approach. All right, overruled.
Okay, do you remember the question?
Yes.
What's your answer?
Yes, I have.
And did the state explain to you the theory of the case here today?
Meaning?
what they had to prove in order to get a conviction on Mrs. Anderson?
Yes.
Okay. And do you think that that ultimately changed your testimony here in court, that conversation?
No.
You would have testified about these things no matter what?
Yes.
Okay. When you yelled at her on the video, you thought that she was responsible for orchestrating that party and providing alcohol, didn't you?
No.
That's what she said.
No. I said you and your boss, referring to Mrs. Brody.
So you meant just her boss, or you meant she was part of it?
Didn't mean any of them. I said she was there with it, not responsible for it.
And you said that she was drinking with juveniles, right?
Yes.
Yes.
Yeah.
And you didn't know that to be true at all, did you?
Correct. Other than her saying she was there at the party.
You certainly didn't see her drinking with any juveniles, did you?
No.
In fact, you never even went into that house, did you?
I didn't. No.
Did any members of the Cocoa Beach Police Department go in that house that night?
I don't know the answer to that.
Okay. And you testified that you had no way of arresting Mrs. Anderson at that moment.
Yes.
That's not true either, is it?
No, that's true.
You had a radio, right?
Yes.
And you could have used your radio to call another police car, which was probably 2 minutes away, correct?
Yes.
And you knew that CR was going to be waiting for his mother for another hour anyway, right?
Yeah.
So you could have sat in the police car, asked Miss Anderson to stay put, and another police car could have come and arrested her. Right?
Could have.
But you chose not to do that, correct?
Yes.
And you chose not to do that because you didn't actually see her commit a real criminal offense, correct?
No, that's not why.
That's not right. When she walked up to you, do you think she was trying to commit a crime?
No.
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 So you think she committed a crime by accident?
Not really a possibility.
Pardon me? I couldn't.
It's not really a possibility, but
It's not a possibility.
no.
Because you can't commit a crime by accident.
Correct.
Crimes involve intent, right?
You may approach. All right, I'm going to sustain that.
Okay, Your Honor. May I have one moment to speak with Mrs. Anderson?
Yes, you may. All right, thank you. All right, so you can step down and you're subject to recall. All right, state, anything else? Any other witnesses? Okay. All right, so this appears to be a good time for us to take a comfort break recess. So I'm going to have the deputy take you out. I would ask you please to leave your written materials, leave everything here with you on your chair. And then I'd also ask you to follow the instructions that I've given you. You've now heard testimony and seen some evidence. Please do not discuss with your fellow jurors anything about what you've seen so far in the trial. Okay? Thank you. All right, everyone may be seated. All right, are the parties needing a comfort break at this time? And then, okay, we want to do that. I was thinking we give about a 10-minute break for comfort break and then come back and discuss how we're proceeding. Okay. All right, court will be in recess for 10 minutes.
building with the white columns on the side. I'm upstairs. Yeah, so there's a surf camp there. The top hall's got a surf camp there. That's downstairs.
Oh, that's Summers' brother. No,
So if you ever need a surf coach and a criminal defense attorney, that's the building you go to. One-stop shop.
Oh, no, I'm glad you guys are moving this thing along. It should be, she could run it down fairly shortly, not too long after lunch.
I was married to Summers' last name Holland. You forget what you're saying, but she's in yes.
I guess that's kind of what I'm doing. You want to sit over here with your media friend?
Fine.
So you got separate. I don't know. Well, enemies or media competitors? I don't know. Oh, never mind. Now it started.
Well, that's probably where I'm going to use.
Oh, well, I figured it out, obviously. But no, I didn't know.
We're done with that, right?
I was only one.
Oh, thank you.
I usually see you out there at the line and log so much, you spend all your time at the gate. Yeah, I think it's like 2 or 3 a week.
It's too late. At least let me tell her what.
right, so counsel, as the state is now rested, anything that you would like to address with the court?
Judge, I move for judgment of acquittal on counts 1 and 2.
Okay.
The basis of my motion is the evidence taken in the most favorable light to the state still doesn't consist of a crime. That's count 1. The state's witness testified, Andrew wrote that nothing that Mrs. Anderson did placed anybody in any danger. The video showed the defendant or the juvenile was in the back seat of the police car when she came out of the darkness with concerns, not trying to commit a crime. And basically, she used words alone, which are protected by free speech. Corporal Brown said that he didn't really see her committing a crime, and that she had endangered the life of CR by having a 2-minute conversation with him, which is really just ridiculous. And I do have a case that stands for the proposition that words alone rarely rise to the level of instruction regarding persistent without violence. That is M.M. A Child versus State, 51 South 3rd, 614. And I have a few cases regarding disorderly intoxication, which also stands for the proposition that words alone are not enough unless somebody is in danger. So just the bare assertion from Corporal Brown that the child was endangered by Mrs. Anderson having a brief interaction with them, I don't think that rises to the level of disorderly intoxication. It doesn't rise to the level of endangerment.
Okay.
So the court should dismiss both of those counts at this point in time. And I'd be happy to provide those cases to you.
Yes, I was going to say, do you have a copy for the state and the court, or?
I don't know how this happened, but I only have one copy of the M.M. A Child case.
Okay.
The other ones I do have copies of.
All right. So provide the copies that you have, and then we can get the site for the other one. We can maybe access it. You may. That's the MM one that you said. Just give me the site and I can. 51 South 3rd. The record is 51 South 3rd, 614, First DCA in 2011. All right.
I believe this is actually 3 copies of the same.
Oh. Yeah, I have Papalis also, and it appears that I have 3 copies of it too. So, all right. All right, and so the Papalis case is the one related to, all right, disorderly intoxication. All right. All right, anything further, Mr. Weaver? Okay. All right, state, I'll hear you in response. Does that conclude? All right. All right, so I am going to just take a brief few minutes just to look at both of these cases. I'm familiar with them, but I just want to read them before making the ruling. I will say a recess for about 10 minutes at most. Okay.
We kept it out. It was mentioned in jury selection that he come up with it from. She's 20 minutes from her neighbor, so.
Yeah. They have a decent blueberry season up there this year?
I did not go to it, but
Did
I'm
they?
pretty sure.
We were just talking about it. It's that time of year.
I've gone for, when the kids were little, they would come up with the blueberry, like, you're not supposed to eat them. Like,
Yes. I was going for a week home. I went in the blueberry college. And blueberry pie.
but yeah.
And then that was a sugar.
Yes, 1 o'clock. All right, so the court is going to be in recess and ask that the parties be back at 1 o'clock this afternoon. We are back on record in State of Florida versus Carly Gail Anderson. And all right, and are both parties ready to proceed?
Yeah, sure.
Okay. All right. All right. All right, and are we wanting to do, or are you prepared to do the charge conference at this time? Yes? Okay. All right, so I am in receipt of the instructions that were provided by the state attorney's office yesterday, and I'm also in receipt of 29.1 disorderly intoxication, and also 21.2 the resisting officer without violence, that proposed instructions that the defense has provided to the court. So, all right, so let's just start with the 2.7 closing argument. Of course, I would read that prior to closing argument. You're following along with me. Okay. All right, 3.1, introduction to final instructions. Nothing different about that. All right, and then 3.2, statement of the charges. Any objection to how that has been prepared? All right, and it is after I would read 3.2 that I would then read the disorderly intoxication, and after disorderly intoxication is count 1, count 2, resisting an officer without violence. All right, so at this time the state has submitted a copy, and then of course I have a different copy from defense. This time we can go ahead and discuss this instruction. Are you still seeking to have special information provided in the instruction?
Yes, sure.
Okay. All right. All right, and state, have you had an opportunity to look at the proposed instruction that the defense has provided?
Yes, Judge. The state would object to the special instruction. I do have case law to provide
Okay.
regarding when a defendant is entitled to special jury instruction.
Okay. Please provide that to the defense in the court. Thank you.
In this case, which is Sunship versus State of Florida, the court held that a defendant is entitled to special jury instruction if the following three elements are satisfied. One being the special instruction was supported by the evidence. Two, the
All right, so you're asking that really everything under the optional definition you've addressed, and you would want none of that to be included, correct? All right. All right, and your response, Mr. Weaver?
So I agree that subsection B shouldn't be included.
Okay.
Because the state didn't proceed on that theory. Or the rest of it is standard. I see the state's is different than mine, but and then this is a case where the conduct that Mrs. Anderson is accused of violating the law for is strictly verbal. So I think that some instruction on First Amendment is appropriate. It is part of the law in this case and in every case. And I asked Corporal Brown if she did anything other than just verbal acts, and he said no, nothing but verbal. So there should be some instruction from the court that there is such a thing as the First Amendment, and that people have the right to free speech. And this instruction that I provided is taken out of the case that I provided yesterday.
All right.
Just one little thing, Roger, it doesn't have to be exactly the way I wrote it, but the court should instruct them somehow on a person's right to free speech under the First Amendment.
All right, and did you want to also argue the resisting language too?
If you give the First Amendment instruction, you don't have to do it twice as far as I'm concerned.
Okay, so you would not want it on that one. Okay.
It doesn't have to be attached to either one in particular, it just has to be an instruction from the court.
Okay.
It's my request and my opinion.
All right, so I have considered, I had a chance yesterday to look at what you have proposed, and I took some time to look at as much case law as I could look at for disorderly intoxication and resisting, and officer without violence. I am going to deny the special instruction that you have proposed here. And let me start with the disorderly intoxication. That standard instruction was adopted back in 1981. I did note that it appeared that there was an amendment to it in November 20th of 2020. For sure, the bulk of all the case law I reviewed regarding free speech and these two crimes was before 2020. And I do feel like when it was amended in 2020, if they wanted that included, that it would have been included. And I do think that you've addressed it in your opening. I do believe it's fair for you to argue that during closing argument regarding free speech, but I don't think that the court should provide an instruction as you have asked for in this. And just let me say on the resisting, the same thing, I looked at that for free speech. I looked at the case law. The instruction was adopted also in 1981, and it's been amended 4 times, 1989, 1995, 2008, and then 2014. And, no information or no optional definitions or no instructions have been included regarding free speech for the resisting an officer without violence either. So I am going to deny the special instruction that you have provided. So,
Okay, I would like, if it's possible, for the court to make those instructions part of the record of this case.
okay, that I will absolutely do that, but I will say that I have written my own notes on them. I don't know if you have other copies that you could provide. You don't have to provide them right this moment, but you could provide them for the conclusion of the trial. I have, yeah, I've got to put some notes and circled some things and just, made a lot of notations.
I do have one more set, Judge. Maybe I can give it to you after the closing argument.
Yes, yeah, if you can keep a note, and maybe Madam Clerk, if you can note that he wants to provide that as part of the record for appellate review. So, all right. So, based on that ruling, I want us to look at the ones that have been provided by the State Attorney's Office and make sure we all agree to the language. So starting with 29.1, disorderly intoxication. To prove the crime, the state must prove the following two elements beyond a reasonable doubt. One, that Carly Gail Anderson was intoxicated, and two, she endangered the safety of another person. You have crossed out property. So we take the brackets off of person. And then there is an intoxication definition that just read it to make sure that the pronouns are correct. All right, so I have read that. Any issue with that from either party? Okay. All right, moving to 29.2. Resisting an officer without violence. To prove that crime, their state must prove the following four elements beyond a reasonable doubt as to the alleged victim named below. So number one would be Carly Gail Anderson obstructed Corporal Demetrius Brown. We would take the brackets out of that. Number two, at the time Corporal Brown was engaged in the lawful execution of a legal duty, with the brackets out of that. Number three, at the time Corporal Brown was an officer. We're removing the brackets on that. And number four, at the time Carly Gail Anderson knew Corporal Demetrius Brown was an officer. And then the last sentence is the court now instructs you that Corporal Demetrius Brown is an officer within the meaning of the law. Any objection to any of that language at all? And state you're working on those? Yes. Okay. I realize I don't want to go too fast, but if you need me to slow down, let me know that. Thank you. All right. So the next one that I have in the packet is 3.4, when there are lesser included crimes or attempts. Is there any indication that you were intending to argue an attempt in the resisting? Okay. All right. Neither party? All right. So we will discard 3.4. All right, next I'm at 3.7, which is the plea of not guilty, reasonable doubt, and burden of proof instruction that I read during voir dire. The part that has been marked out is in the beginning of the third paragraph, the language starting with except for the defense. There has been no affirmative defense raised at this stage. So that language would go out unless that changes. Anything else that we need to do? All right. All right, the next one is 3.9, weighing the evidence. So in the weighing the evidence instruction, the list starting at number 1 through number 10, we need to make sure we all agree on those. So far, the state has kept in number 1 through 5. So let's take a look at the ones 6 through 10 that have been crossed out to make sure they should stay out. All right, and is the state seeking to keep any of 6 through 10 in the instruction?
No, Judge.
Okay. And defense, are you seeking? If you need to continue reading, that's fine.
I think number 8 is always important.
All right. All right. And state, what is your position regarding number 8?
I don't, I suppose, have an objection to keeping it if defense counsel would like to do so. I'm not sure how relevant or applicable it is here, just because I don't believe that we've had any out-of-court statements introduced that would contradict anything that was provided during testimony.
So you said you believe it's a good idea to keep it in, but you have something specific that you were thinking would aid the jury in keeping this instruction in.
Well, the out-of-court statements are on the body cam video. And Demetrius Brown, Corporal Brown, also makes statements on that video.
Right, okay. And state your response to that.
I don't believe that Corporal Brown made any statements during his testimony today that would be inconsistent with any of the statements that he made to Ms. Anderson during their interaction.
All right. And then defense? You have an intention to argue that in closing?
When he was yelling at her, he accused her of participating in the party, drinking with minors. In court, he said that he didn't do that. And so that is not a court statement to be contradicted in court.
Okay. And state, do you want to give a response to that?
Just briefly, I think that was cleared up during Corporal Brown's testimony that on the video, the statement that he had said was, you're here hanging out at this party with your boss, with kids that are drinking. And that was said to her in response after she said, I've been here hanging out at this party. And I think he explained during his testimony today that when he said that to her, he was referring to her statement that she had said she'd been hanging out at the party, and he clarified during his testimony on cross that he was not insinuating that she was responsible for the party or had been the one conducting the party, merely that she was hanging out at the party because that's what she had told him.
All right. All right, I am going to allow the question. I do think that it's available to both parties during closing argument to discuss that if needed, the information that you just provided to the court. So if you would include number 8, which now would actually be number 6. It'll become number 6, please.
Yes, Judge.
All right, and Mr. Weaver, was that the only one out of the ones marked through that you were requesting be included? Okay.
Yes.
All right, and then looking at the 2 paragraphs at the bottom of the page after the numbered information, is there anything that's objectionable in that? Regarding the number of witnesses, number of offered, and also law enforcement law enforcement being employed as a law enforcement officer. All right, and then on the second page of 3.9, there's a paragraph about expert witnesses crossed out, and the next two paragraphs also regarding testimony of a child. At this stage, the defendant has not become a witness, so that is marked out. If we mark all of that out, that from the very beginning of the top of page 2, the court would then start at, it is entirely proper for a lawyer to talk to a witness about what testimony and so on. And then I would read the final sentences. You may rely upon your own conclusion about the credibility of any witness. So you would want those two paragraphs included at the bottom. Okay. I mean, they may, yeah, they'll fall to the beginning of the. All right, anything else that we need to address in 3.9, weighing the evidence from either party? Okay. All right, we're going to move to 3.9, subsection A, defendant not testifying. That's currently our state right now, okay? And you would want that included. And is it, have you had a chance to read it and confirm that it is appropriate for? All right. Yeah, I had an opportunity to read during lunch to make sure pronouns read appropriately. All right, next we're going to move to 3.9, subsection B, defendant statements. All right, any party has an issue with either party has an issue with it? All right, thank you. All right, next one that was included in the packet is 3.9E, eyewitness identification. Does not seem to apply in this trial, but both parties agree? All right, so we will remove that one. 3.10 is rules for deliberation, the standard instruction. And was there anything on that that you wanted to raise as an issue? All right, 3.11 is the cautionary instruction. Few sentences there. It seems appropriate. Anything that you raise for that? All right, 3.12 verdict. You may find the defendant guilty as charged or not guilty. We would take out the bracketed language because we don't have a lesser included. And then we would take out the next paragraph regarding the verdict should be for the highest offense on the verdict form. So I would say the first sentence that I said, then I would say the verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows, and I will be going over them. So the language that you have crossed out, of course, would be removed too. All right, so any objection as to how that one reads?
So just to clarify.
Sure.
It will be, you may find the defendant guilty as charged or not guilty, and then straight into the verdict must be unanimous?
Yes, yes. The state is not requesting that that paragraph be there at all. Okay, just making sure. All right. All right, so I do have two verdict forms. All right, and the first one that I would read to them would be, we, the jury, find as follows: as to Carly Gale Anderson for the charge of disorderly intoxication, check only one. All right, so I'd definitely read that as count one, and then the second one, we, the jury, find as follows: as to Carly Gale Anderson for the charge of resisting an officer without violence. I have confirmed we're in the county court, and we've got the right case number, the right defendant's name and spelling. Option A. Option A does say is guilty of both of disorderly intoxication and of resisting an officer. Option B does read the defendant, Carly Gail Anderson, is not guilty on both verdict forms. And then, so say we all, this day of month 2025 in Brevard County, Florida, there is a line for the foreperson to sign.
We did notice that the case number and on the forms I printed out as AXXXXX, the last two should be DC.
DC. Yeah. You have changed them already?
I just did.
All right, thank you. Yeah. All right. All right, so anything about the verdict form that you would like to address? Verdict forms.
I always think not guilty should be first, but
Okay.
I never win that argument.
So you want to raise that argument, you can.
It's okay.
Okay. All right, so moving to 3.12 subsection A, single defendant, multiple counts or informations. So a separate crime is charged in each count. The information, although they've been tried together, each crime and the evidence applicable to it must be considered separately in a separate verdict form, separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect the verdict as to the other crimes charged. Anything about that instruction? Okay. All right, now we're at 3.13, submitting case to the jury. Well, did you find anything in that one that you would like to raise?
It's the standard instruction, I think.
I think that I did want to, let's address this briefly. So we have one item in evidence, which is the body camera footage. It's very brief. We do have we have two options. We can send it back with them with the clerk of court computer. We have a laptop computer. Or if they want to view it again, we could bring them back into the courtroom. So, okay. And state, what is your position about that?
The state has no objection to them viewing it in the jury room if that's easier for everyone.
Okay.
That gives them the ability to watch it, pause it, play it, talk about it together without being in the presence of all of us. I think that gives them, it makes probably their deliberations easier in their conversations with one another.
All right. Defense, any objection to that?
I'd like to know what they're doing, so I'd ask her to be done in the court.
Can you expound on that a little bit? Because during deliberations, we don't get to know what they do, what they say, what they consider. So, being that it's such a brief video, we're not sending them back a 30-minute video, sending, what you've said a few times is 2-minute video or 3-minute video. And the time it would take to bring them out, set it up, do all that, they may.
Someone going to show how to use the laptop that's provided to them?
So that is always a concern that we do have a laptop, and I will tell you that we can look at that laptop too. We want to look at it to make sure that it is clean and clear with nothing else on it that they can access, which I know the deputy clerks do check that, but we also could check that too. We could, it was a thumb drive, I guess, or flash drive.
That video is the only thing on that.
Thing on that too? Okay, all right. So, I guess part of the thing I could consider is I don't know their technical know-how or not either. So, I also could offer both options to them if you're in agreement with that.
That's probably fine.
Okay. And like I said, if either the state defense, if you want to look at the laptop before we send it back, we can certainly do that. I have done that in the past myself. As the judge, I look at it, but you are welcome to look at it too. That is the only thing. It is locked up in that closet. It's only used for this purpose, to to be sent back with the jury. It's never used in any, we never use it to present evidence, you know, in other hearings or things like that. It's only for jury use. Is that correct, Madam Clerk? Yes. Yeah, so given that information, the parties would be fine with me telling the jury that they could watch it back there, and we would provide them the computer to do that, or if they would prefer to watch it on the big screen out here, they could send a note to me to tell. All right, so I just need to all right, and then the last instruction I have, of course, is 4.2, which is the instruction upon discharge of the jury once they have returned conclusion of the deliberations. Any objection to anything there? All right. All right, so can the parties please approach? All right, so Mr. Weaver, at this time, I am going to inquire with your client, Ms. Anderson, about her decision to testify or to not testify.
Yes, Your Honor.
And Ms. Anderson, at the beginning of court today, I did place you under oath to tell the truth to the court, and you are still under oath to tell the truth. Understand that?
Yes.
All right. All right, so at this time, I'm going to also ask you a series of questions about your decision regarding whether to testify or not testify. So I want you to understand that the court is asking these questions. Please don't believe that the court has any preference in whether you testify or not. The decision is solely your decision. So number one, do you understand that you have an absolute constitutional right to testify during this trial?
I do.
Do you also understand that you have an absolute constitutional right not to testify in this trial?
I do.
Number three, do you understand that it is your decision and not the decision of your attorney?
I do.
Number four, do you understand that you may seek his advice regarding the decision to testify, but that ultimately it must be your decision?
I understand.
All right, and lastly, what is the decision that you have made regarding to testify or not testify?
I'm not going to testify.
Okay. All right. Court wants you to understand that this decision is final, and you cannot at and say that you wanted to testify.
I understand.
All right. And let me ask this too. Does either party need a comfort break before we bring the jury in? Want a short comfort break at all?
Not the defense.
Okay, just making sure. All right. You may. Thank you. All right, and I'm going to actually have the parties approach one more time for something real brief, please. All right, so Deputy, you can bring the jury in, please. Secretary may enter. All right, you may be seated. Everyone else may be seated. All right, members of the jury, I want to thank you for your patience in that break that we took that extended into our lunch hour, and I want to assure you that we got a lot of different business done during that time. Hold it. Did anything happen on our recess? The court. With all of you that all right. State and the defendant will have equal time. Is entitled to divide time for opening argument. All right, state, you may proceed.
Good afternoon. To prove the crime of disorderly intoxication, the state must prove the following two elements beyond a reasonable doubt. Number one, that Carly Anderson was intoxicated. And two, that she endangered the safety of another person. The judge is going to, and following these closing arguments, provide you with some jury instructions, and this information will be provided in the jury instructions. And these instructions also include the definition of intoxication, which states that intoxication means more than merely being under the influence of an alcoholic beverage. Intoxication means that the defendant must have been so affected from the drinking of an alcoholic beverage as to have lost or been deprived of the normal control of either her body or her mental faculties, or both. Intoxication is synonymous with drunk. You heard testimony today from Corporal Demetrius Brown. He testified that when he approached the defendant after he heard her yelling at the EMTs, he observed her to be flushed, that she was slurring her words, and he immediately noticed the strong odor of an alcoholic beverage emitting from her person. You also saw for yourselves, watching the body camera footage, which you will also have the opportunity to watch again when you were deliberating, that she clearly appeared intoxicated on the video. You also observed on the body camera footage that when Corporal Demetrius Brown told the defendant that she was drunk or intoxicated, he initially denied it and said, "No, I'm not." And then after he insisted again later in the conversation, "You're intoxicated," her response was, "Oh, so what?" Carly Anderson was not only intoxicated at the time of this interaction with Corporal Brown, but she knew that she was intoxicated. And that second element, she endangered the safety of another person. Her interaction with Corporal Brown, or yelling at the EMTs, causing a scene, being drunk and belligerent, endangered the safety of the minor child, CR, who was in the back of the patrol car at the time that all of this was going down. Whether this encounter lasted 30 seconds, a minute and 30 seconds, 2 minutes, 3 minutes, an hour, that doesn't really matter. Something bad could have happened in the matter of moments. This was not a drunk adult at a bar who'd had one too many beers and had experienced something like this before. This was a child. And at the time that the child was in the patrol car, the only person who was responsible for him and was there to supervise him was Corporal Brown. As Corporal Brown testified, he'd been vomiting throughout the night. He vomited continuously in Corporal Brown's patrol car. He was clearly extremely intoxicated and impaired. Corporal Brown testified that he had concerns. He was so concerned about his well-being that he contacted the fire department to come and check on him to make sure that it wasn't a true medical emergency, that they didn't need to transport him to the emergency room. And thankfully, they determined that he did not need emergency medical care. But that does not mean that he was not impaired to the extent that something worse could not have resulted from that. While he was in the back of the car, Corporal Brown testified that he was concerned that he could have had a seizure, regurgitated, vomited, choked on his vomit. He was not even able to stand up on his own. You saw in the video that Corporal Brown had to ask the EMTs for help just getting him from the side of the road to the car. So regardless of how brief the defendant's behavior was or how long that drew Corporal Brown's attention away from the child, anything could have happened in the time frame where Corporal Brown was forced to divert his attention from the child that was under his care to the defendant. Moving on to the second charge, which is resisting an officer without violence. To prove the crime of resisting an officer without violence, the state must prove all of the following four elements beyond a reasonable doubt. Number one is that Carly Gail Anderson obstructed Corporal Demetrius Brown. Obstructing being hindering, preventing, delaying. And at the time, Corporal Brown was engaged in the lawful execution of a legal duty. Number three, Corporal Brown was an officer. And number four, at the time, Carly Anderson knew that Corporal Brown was an officer. The judge is going to explain to you when she provides you with the jury instructions that Corporal Brown is an officer within the meaning of this law. So let's go through those a little bit. The first element, Carly Anderson obstructed Corporal Demetrius Brown. Corporal Brown testified today that in having to divert his attention away to deal with her, she absolutely obstructed him. She hindered his ability to focus on the task that should have been his primary focus at that time, which was caring for the sick, impaired juvenile that was in the back of his car. She delayed him from transporting the juvenile and from supervising the juvenile because, as he testified earlier today, he could not just walk away and throw his hands up and leave after he heard her and observed her yelling at and berating the EMTs that were on scene. He had a duty as a police officer to go and investigate that situation to make sure that what was going on, make sure that it didn't escalate any further, and address if there were any real problems that were going on back there that she was causing. The second element, at the time, Corporal Brown was engaged in the lawful execution of legal duty. As Corporal Brown explained earlier in his testimony, part of his legal duty is to be a community caretaker. The role of a police officer is very broad. You know, when we see TV shows and movies, it's all just arresting the bad guys and going on pursuits and craziness. But the role of a police officer also includes taking care of members of the community when they are in need. And I don't know who, if anyone, could be more in need than that minor child that night. And thank goodness that Corporal Brown happened upon him when he did, because he clearly had no way to get home by himself. And thankfully, Corporal Brown was able to contact his mother to let her know what was going on, so that she could then come and assist him. The third element, that Corporal Brown was an officer, that's undisputed. Corporal Brown is a police officer, and he was at the time that his interaction took place with Miss Anderson. And the last element, that Carly Anderson knew that Corporal Brown was an officer. As we heard Officer Brown testify, Corporal Brown, I apologize. Not only was he in uniform that night, clearly on duty in his marked patrol vehicle, but Ms. Anderson knew from her previous experience with him that he is a police officer. So she's aware that he's an officer, and it was clear that he was an officer on duty that night when this incident occurred, because he's at the scene in his patrol car in uniform. Ms. Anderson isn't being charged for drinking with juveniles or having anything to do with conducting the party that took place. Those are not the charges that the state has filed against her or is pursuing. Corporal Brown testified that he didn't arrest her. Why? He couldn't. You could only have one person in the back of a police car at a time, and the minor child was already in the back of his police car. So he had no way of placing her under arrest at that time. His focus was not on her, it was on the child. His main goal was to end that encounter with her and get back to what his real focus was, which was getting the child back to the station so that he could supervise him and make sure he was okay until his mother was able to come and pick him up. You heard defense counsel ask Corporal Brown about why didn't he just give the minor child to knock on the door of 44 Country Club Road and give the child back to the house where the party occurred. I would argue that would not have been an appropriate or reasonable thing to do, to return him to a house where clearly there were hundreds of impaired juveniles. This is where the juvenile just came from. He's sick, he's a minor, where are his parents? And not only that, but it is clear based on the body camera footage that Miss Anderson was intoxicated. Were the other adults intoxicated? Who knows? But I don't believe, and I would argue to you, that Corporal Brown had any other option other than to take the child back to his mother rather than knock on the door of a nearby residence and say, hey, you take it. That would not be a very appropriate thing to do for a police officer. You'll have the opportunity when you're back in the deliberation room to watch the video. I recommend that you do that. Watch it as many times as you feel like you need to. And I feel like when you watch that video, it will become clear to you that Miss Anderson was without a doubt intoxicated, endangered the safety of the minor child's CR, and obstructed Corporal Brown, hindered him, delayed him, prevented him from being able to maintain his focus on what it should have been on, which was the child all along. At this time, the state would ask you to return a verdict of guilty for both counts, for the disorderly intoxication and for the resisting an officer without violence. Thank you.
All right, defense, you can now proceed. Closing argument.
Thank you, Your Honor. Afternoon, ladies and gentlemen. So now you know what the evidence is in the case. And it's really hard to believe that this is what a prosecution is based on. However, here we are. So, as to disorderly intoxication, remember, everything has to be decided to the standard beyond a reasonable doubt. Was Miss Anderson intoxicated? Maybe so. Because of her intoxication, did she endanger the drunk high school student in the back of the police car? Absolutely not. That's ridiculous. Absolutely ridiculous. Can't say that beyond a reasonable doubt. The state says the child could have vomited and inhaled it. Child could have had a medical emergency, could have done this, could have done that. That's not good enough for conviction in criminal court. As to resisting without, she walked up to somebody she knew and talked to him about what was going on. She didn't obstruct him. He didn't have to talk to her in any way. And he said that. He wasn't really engaged in any lawful duty. Taking a kid back to the police department isn't really what the police do. He could have taken him to jail. That might have been a lawful duty. And Mrs. Anderson didn't obstruct him from doing anything. She had a very brief, elevated conversation with him when she said over and over again, I'm concerned. I'm concerned about the child. And Corporal Brown could have asked CR, what are your plans for the night? Where are you planning on staying? Was he there visiting the high school student who was really hosting that party? Did he have another place to go? Obviously, his mother was in Orlando. He had something to do other than sleep on the yard that night. So we don't know what his plans were. And then Corporal Brown takes him to the police department, doesn't even take him inside, leaves him in the back of the police car for at least an hour, which is how long it takes for somebody to drive from Orlando to Cocoa Beach. So what happened in this case is it got a lot of publicity. Initially, it was believed that Miss Anderson had something to do with this party, but that wasn't true. So there was a lot of publicity, a lot of pressure on the state attorney's office to file something. Got to get her on something. And this is just made up stuff. To say that she endangered a kid who was already in the back of a police car when she walked up and had a conversation with somebody she knew is ridiculous. I would admit to you that this is not her finest moment. And she probably shouldn't have been interjecting herself in that situation. She shouldn't have been talking to the police officer that way. However, what she did is not a crime. Being convicted of a crime is a serious matter in our society, and it should not be taken lightly. And when you look at that video with no instructions, no background, you'll see somebody having a conversation, whatever you want to call it, with a police officer. That is not a crime under any circumstances, especially not under these circumstances. And she is protected by the First Amendment, which includes the right to freedom of speech. And as long as her free speech didn't cross the line and really become a crime, she shouldn't be convicted of anything. I asked the paramedic, Andrew Rock, did she endanger CR? He said no. He said that her CR's vital signs were great. And I asked him simply, did she endanger him? No. And he was right there. And I asked him, did you see her commit a crime? He said, no, sir. He did not. Well, Corporal Brown, part of the police department, part really of the prosecution team in this case, he was instructed somewhere along the line as to the theory of this case, and he had to come in and say, yeah, I did talk to her, but because I chose to talk to her, CR was in danger. And that's just not true. It's absolutely not true. And you certainly can't find that CR was endangered by that brief conversation by a reasonable doubt. Corporal Brown could have said, hi, Carly, leave me alone. I can't deal with you right now. I'm taking this kid to the police department to sit in the car with him for the next hour while his mom shows up. He didn't do that. He had a consensual encounter with her because that's what he wanted to do. And when he felt that when he was done with it, he burst into an outburst and started yelling at her, said, leave me alone, get out of my face, and she did that. She was given a direct order by a police officer, and she complied. Up until then, she wasn't given any orders. He was talking to her, and she was saying, I'm concerned. I'm concerned. She used that word several times. So, because this case got out of control, received all this media attention, the state attorney's office has felt the need to squeeze something out of it. And the only choice Mrs. Anderson had was to take it to you, take it to the people. And she's asking that you give her the benefit of every reasonable doubt. If you want to look at the video again, you can. It's just as bad as the first time you saw it. She's having bad behavior, but it's not a crime. I asked Corporal Brown, you saw her commit a crime? You could have arrested her right then, right? And he would have. Absolutely. He could get on his police radio, say, hey, drunk CR, hang on 1 minute. We got to wait for another cop car to get here, which might take 2 minutes. And then he would suggest to one of the other officers, go ahead and take CR or take Carly. If he had observed a crime, either of these crimes, while he's working as a police officer, he would have made a move. He would have arrested her and maybe taken them both back to the police department with Carly in handcuffs. He didn't do that. He didn't see any crime. The paramedic, who obviously was a little bit nervous today, testified truthfully. I could say that I would bet that's the first time he's ever testified in court, because he looked a little nervous, and he absolutely told the truth. CR was not in danger and did not see Mrs. Anderson commit any crime. As to the community caregiver, that's also ridiculousness. Police officers was there to enforce the laws about noise violations and try to make this party go away. He was a nice enough guy to call the mother, who apparently doesn't have any fault in this case. Why is she letting CR come all the way over here and get himself so drunk that he gets to ride back to the police department in the back of a car? Nobody said anything about her. And anyhow, Corporal Brown could have had many options. He could have knocked on the door and said, is anybody here with CR? Who's supposed to be taking care of him tonight? Because he needs to be watched for a few minutes while he sobers up. So, when you look at the video, which you've already done, it should strike you immediately that that wasn't great behavior. It wasn't Mrs. Anderson's best moment. It wasn't very becoming, but it's not a crime either. And please don't make a mistake of making her a convicted criminal over this behavior when she had the absolute right to walk up to somebody she knows and say, what's going on? Even if she was a little bit intoxicated, she could have walked up and said, what's going on? I'm concerned. And Corporal Brown really had a duty to alleviate her fears too. She saw a kid being placed in the back of a police car, and I can tell you that 99% of the time somebody gets in the back of a police car, they are under arrest. They're not being driven around by Cocoa Beach PD Uber. They are going to the police department and then to jail. So that's what she saw. She said she's concerned, and she acted on her concern. She got into this whole thing by going out for drinks with her friend who was facing much more serious charges in another case. That's where the state attorney's office should be focused. If they're focused anywhere, they should be trying to squeeze some sort of conviction, something out of this behavior. This is free speech, constitutionally protected. No matter how you look at it, she didn't endanger anybody. So I'm asking you to consider these things, find Mrs. Anderson, who was a very nice lady, not guilty.
All right, State, if you have a rebuttal argument, you may proceed with that.
This case is not about First Amendment or protected speech or free speech. It's not even about what exactly Ms. Anderson was saying. It's about her behavior, the way that she drunkenly interjected herself into a situation that was none of her business, that she had no business being a part of, and that behavior is what caused all of these events to unfold. Defense counsel argued that, yes, the child could have had a seizure. The child could have vomited and choked on. The child could have this or that, but he didn't. And it's true, he did not. But that's not what endangered means. The state does not have to prove that she caused injury to this child or that some terrible medical episode did occur as a result of the behavior, but rather that he was in danger. What does that mean? He was placed in harm's way. There was a possibility of danger there that leaving him extremely impaired as a child in the back of a car, vomiting, with nobody else around, could have led to the possibility that something bad could have happened, that his safety was endangered. Defense counsel stated that Ms. Anderson walked up to someone she knew, just wanting to see what was going on. But that's not what the evidence that you heard today showed. She didn't walk up to Corporal Brown initially. She walked up to the EMTs. She didn't know them. They had no idea who she was. She just appeared out of nowhere, wanting to know what was going on. They kindly told her that they could not tell her what was going on. They're not allowed to provide her with any information, and she needs to go away. It wasn't until, as you saw in the video, Corporal Brown then walks over and she immediately sees him. Corporal Brown, someone she knows. Then she starts interacting with Corporal Brown. Defense counsel stating that Corporal Brown didn't have to talk to her. We know that that's not true because we heard from Corporal Brown today that he has a duty to go back there and see what's going on. He can't just take off and leave. He does have to talk to her. Corporal Brown testified today that his intention wasn't to go back there and have a long conversation with her. His intention was to tell her, like, hey, you need to calm down. Like, it's okay. He was attempting to try to calm her and ameliorate her concerns, and he was not able to do that due to the intoxicated state that she was in. At the time that he initially encountered her, she is fuming mad, yelling, raging, complaining to him about how the EMTs are so rude and terrible and something needs to be done about them. They can't talk to her that way. And then the conversation escalates from there. He's trying to be reasonable with her. He's trying to calm her down, and she just won't have it. The conversation is going in circles. Why? Because she's intoxicated. She's not grasping anything he's saying. That's why she refers to the car as a machine. Why are you putting that child in that machine? That's an intoxicated person speaking. Nobody refers to a car as a machine. Defense counsel said that he didn't have to help the child. He could have taken the child to jail. Is that what we want law enforcement to do, is when they see an impaired, sick juvenile at a house party, is to just arrest them all immediately at the age of 17, start their criminal career out right then and there for a house party? I hope not. That would be pretty unfortunate. So I don't know what he would have arrested him for or taken him to jail for, but I'm certainly glad that Corporal Brown, rather than deciding to do that, decided to help him. Defense counsel also mentioned that rather than take him into the police station, when they get to the police station, he left him in the back of the police car. That's not what happened. As we heard from Corporal Brown earlier, he didn't just leave him there in the car by himself. He stayed with him, and that is where they decided to stay, likely because it was probably hard to try to move the juvenile again, as you saw how difficult it was the first time. And if the juvenile is still vomiting, and he's already vomited all over the police car, might as well just keep that the area that he's contained in until his mother's able to get there to retrieve him. This is not just made up stuff. We are not here for made up stuff. We're here because the defendant committed 2 crimes that night: disorderly intoxication and resisting an officer without violence by obstructing Corporal Brown. Defense counsel pointed out that if you just watch that video with no instructions and having no background on what you just saw, then maybe you wouldn't think that there was a crime there. But the background is important. Instructions are important. If we take just a short clip of somebody's life or one small incident, that's not going to paint the rest of the picture of everything else that was happening that night. It's important to think about the background. It's important to think about the instructions that we provide for you here today, and the evidence that you hear, and the testimony, and the video. It all is part of the charges. That's why we're here, because this is important. Your role is important. Defense counsel pointed out that Andrew Rock, the EMT that you heard from earlier, he asked him on cross if he felt like Miss Anderson had endangered the safety of the child. And Mr. Rock stated no. But Mr. Rock didn't see what happened after the fact. They left, the EMTs left, knowing that Corporal Brown was there dealing with the situation. So to ask Andrew Rock whether the juvenile's safety was endangered by the defendant going up and yelling at the EMTs, he's only talking based off of his knowledge, which is that she walked up and yelled at the EMTs, and then they got in the ambulance and said, "Let's get out of here, or this gets crazy," and they left. As far as blaming the child's mother, CR's mother, well, I don't know about you all, but my mother certainly didn't always know everything that I was doing in high school. So I think it's quite unfair to say that whether CR's mother knew where he was or what he was doing, I highly doubt it. Probably unlikely that she knew that her son was extremely impaired at a house party with a bunch of other high schoolers. But high schoolers will be high schoolers. So whether she knew where he was or not is completely irrelevant to the defendant's behavior that evening. Regarding whether Ms. Anderson was truly concerned, defense counsel stated that 99% of the time, I believe he said, when there's someone in the back of a cop car, it's because they're getting arrested. Well, you heard Corporal Brown, who is a police officer, tell you that they put people on the back of cop cars all the time that aren't under arrest to help them. That is part of their role. It's part of their duty to help people, not just to arrest them, to help them. The judge is going to explain to you when she gives you the instructions what reasonable doubt means. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable but one which waves and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. I would ask you to ask yourselves in deliberation whether any of the doubt here is reasonable. You should not have to force yourself to imagine some possibility of doubt that may be floating out there in space somewhere. It has to be a reasonable doubt. And the state has proved to you throughout the course of this trial, beyond any reasonable doubt, that Carly Anderson is guilty of disorderly intoxication and resisting an officer without violence.
All right, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Carly Gail Anderson, the defendant in this case, has been accused of the crimes of disorderly intoxication and resisting an officer without violence. To prove the crime of disorderly intoxication, the state must prove the following two elements beyond a reasonable doubt. Number one, Carly Gail Anderson was intoxicated, and number two, she endangered the safety of another person. Intoxication means more than merely being under the influence of an alcoholic beverage. Intoxication means that the defendant must have been so affected from the drinking of an alcoholic beverage as to have lost or been deprived of the normal control of either her body or her mental faculties, or both. Intoxication is synonymous with drunk. To prove the crime of resisting an officer without violence, the state must prove the following four elements beyond a reasonable doubt as to the alleged victim named below. Number one, Carly Gail Anderson obstructed Corporal Demetrius Brown. Number two, at the time, Corporal Brown was engaged in the lawful execution of a legal duty. Number three, at the time, Corporal Brown was an officer. Number four, at the time, Carly Gail Anderson knew Corporal Demetrius Brown was an officer. And the court now instructs you that Corporal Demetrius Brown is an officer within the meaning of this law. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if you having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in the trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number one, did the witness seem to have an opportunity to see and know the things about with which the witness testified? Number two, did the witness seem to have an accurate memory? Number three, was the witness honest and straightforward in answering the attorney's questions? Number four, did the witness have some interest in how the case should be decided? Number five, does the witness testimony agree with the other testimony and other evidence in the case? And number six, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in this case. A statement claimed to have been made by the defendant outside of the court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, number one, whether when the defendant made the statement, she had been threatened in order to get her to make it. And number two, whether anyone had promised her anything in order to get her to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number 2, this case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or you are angry at anyone. Number 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, the jury is not to discuss any question that a juror wrote that has not been asked by the court and must not hold that against anyone. Number 8, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and they are as follows. In the County Court of 18th Judicial Circuit in and for the Brevard County, Florida, case number 05-2025 MM 013006A, State of Florida, plaintiff versus Carly Gail Anderson, defendant. Verdict. We, the jury, find as follows as to Carly Gail Anderson for the charge of disorderly intoxication. Check only one. A, the defendant, Carly Gail Anderson, is guilty of disorderly intoxication. B, the defendant, Carly Gail Anderson, is not guilty. So say we all, this day of this month, 2025, in Brevard County, Florida, and it will be signed by the foreperson. Additionally, in the County Court of the 18th Judicial Circuit in and for Brevard County, Florida, case number 05-2025 MM 13006A, State of Florida, plaintiff versus Carly Gail Anderson, defendant. Verdict. We, the jury, find as follows as to Carly Gail Anderson for the charge of resisting an officer without violence. Check only one. A, the defendant, Carly Gail Anderson, is guilty of resisting an officer without violence. B, the defendant, Carly Gail Anderson, is not guilty. So say we all, this day of this month in Brevard County, Florida, and there is a signature for the foreperson. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict form returned as to each. A finding of guilt or not guilt as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to bring those verdict forms back into the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until that juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through any telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberation. These communication rules apply until I discharge you at the end of the case. If you become aware of a violation of any of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Now, many of you have cell phones, tablets, laptops, or other electronic devices here with you. The rules do not allow you to bring your phones or any type of these electronic devices into the jury room. Kindly leave those devices on your seats or with the court deputy who will guard those devices while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take a little time. You may continue your deliberations while you wait for the answer. I will answer any questions, if I can, in writing or verbally here in open court. During the trial, an item was received into evidence as an exhibit. You may examine whatever exhibit you think will help you in your deliberations. Now, we are going to give you two options because we have a thumb drive that is the exhibit. The first option is that we can send it back with you to the jury deliberation room with a laptop computer, and you would be able to view it that way, as long as someone has the technical capability of doing it. The second option is, of course, you can write a note requesting that you are brought back into the courtroom, and we would view the video up on the large screen there, and here in the courtroom with the parties and myself. All right, so the foreperson can write me a note when that is decided by the jury. If they need to view the video, would like to view the video, you can provide that to me. All right, in closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. All right, parties, if you would please approach. All right, at this time, ladies and gentlemen, I am going to excuse our alternate jurors. We actually selected 2 alternate jurors. And the first one is Chad Stewart Jr., all right, and Chin Tran. Okay, so both of you, if you can leave your notebooks. Like I said, we will destroy any notes that you have in that. No one will ever read them. You can go ahead and come forward. I just want to say to both of you, thank you very much for your time and your attention and your patience in this matter. Do you have items back in the jury room that you would need to retrieve? Do you have all of your items with you? Yeah, take that. So what you'll do from here is you'll go down to the jury assembly room to let them know that the trial's concluded and you have been released as an alternate. Again, I want to thank you very much for, I know both of you shared how very busy you are in your lives. It's very much appreciated that you are here for this process. So thank you. You look at them and check to see that I took off. I have to know. All right. All right, at this time, the jury may retire to the everything's there. All right. Either party want to review the verdict forms before they go back? All right. All right. We're going to send back a legal pad with the jury for the notes. I am. All right, now confirm there's nothing on it. All right, so at this time, everyone may be seated back there. I want to say to the parties, thank you both, all of you, for your professionalism with this. When you have a trial that has a lot of publicity and a lot of media attention to it, I think everyone was incredibly professional, flexible, and patient to a lot of the different things that we had to do here. And I do want to ask you, Ms. Anderson, are you generally satisfied with the job of your attorney during this trial? All right, thank you for that. All right, so what we'll do is retire until we hear back from the jury. I'd ask everyone to stay pretty close. Anybody, it's 2:45, so anybody need to leave the courthouse, or will you all remain in the courthouse at this time? Are you planning to go to your office?
No, we'll stay.
You're going to stay? All right. And then, Mr. Weaver, you plan to be in the general area?
I'm staying here, Judge.
Thank you. All right.
I would like to make this instruction part of the record.
Okay, you may do that. The instructions for the charges that you wanted added, provide those too. Just the disorderly intoxication one is the one that you wanted to add? Okay, all right. All right, so let's add this if we can. Yes. Part of the record. Yep. All right, anything else that we need to address before we conclude? No? Not from the defense. All right. All right, court will be in recess until we hear back from the jury.
knows the full story, or most of it at least.
Well, depending on what happens, can we grab you after, sir?
Yeah.
Just to.
We'll see what kind of mood I'm in.
I know, I understand totally. We all shall see.
I'm not able to predict what juries are going to have.
Oh, absolutely, no way.
I'm pretty much never right.
Huh?
When it comes to guessing, I'm never right.
Yeah.
You really let go of it.
Well, don't guess on my side then.
No, sir. You do have a great haircut, though.
I like yours too.
You know what?
QR code?
Yeah.
That was really funny. I know thinking about that, I'm like, very clever.
I should do that, huh?
Yeah.
Might
No,
start,
you're probably like, you know what, I don't want a media heavy one.
might start a whole new fashion, huh?
Everyone will follow suit.
Whole new thing.
Hey, Greg.
Yeah.
What's up, bro?
Good, yourself?
Living the
I
dream.
don't know if you heard what she was talking about. Last week, I got a nice picture of the back of my head. So I was thinking over the weekend I should have a QR code tattooed right here that links to my law firm site,
You know what?
my OnlyFans site.
I'm sitting here thinking, if the whole law thing don't work out, you got a future in marketing.
Yeah.
That's a great idea. I love it.
We could do the same.
Hey, man, gotta do what we gotta do.
Yep, that's right.
I have seen people wearing T-shirts with QR codes on the back.
Yeah,
In most cases, it's some kind of a foul message, but yeah, it's a good idea.
Well, we've gotten stories about the moms of the kids who go to like the private Christian schools and
Yeah.
they put their OnlyFans on their car.
oh yeah.
And then all the other parents freak out and it's like, we can't have this mom dropping off their kids because the OnlyFans. So then they get like,
Yeah.
you have to go over to the strip mall and make your kids walk over because we can. No, really, like we've all covered that. Like, it's wild.
OnlyFans moms need to take their kids to public school.
Yeah, they're like, they cannot go to private Christian school. Like that's the argument that the other parents are making. It's
These
wild.
times we live in.
No, it's
It's a
really
great time.
interesting.
People are very judgmental.
Yeah.
Aren't they?
Mhm.
Oh, boy. I need a vacation.
Yeah.
I'll watch your stuff.
Yeah, I'm gonna do.
That's what I'm gonna do.
Be here just in case it goes long.
Yeah, because they moved James to somewhere else. I don't know where he went. They didn't tell me to get here till like 12:30.
Oh,
My
geez.
seminar was. I was here. I was pool yesterday. So I was here yesterday. And then I thought James was gonna take care of it today. And they're like, oh no, we moved him something else. Like, go ahead. We want someone down there. So go ahead. Sure. Yeah, why not?
Interesting.
He just told you that and invited you. Oh, they were, okay. All right, I don't know what the state would do. Yeah, if you could, yeah. All right, and is your client?
She's right here somewhere.
Okay.
see.
All right, Digital, if we can go on record briefly, we have a question or a request from the jury. All right, so for the record, council's present with Ms. Anderson. The two assistant state attorneys are also present. So we have received a note that says that we would like the laptop, please. So, we have pulled the laptop out. It does have a power cord with it too, so
Who's the note signed by?
it is not signed by anyone. There's no signature, so I don't know that they got to, I would think they got a 4-person right away, but they, yeah. So, all right, and any objection to me sending back the laptop and State's Exhibit 1? All right, State, any objection to allowing them that option 1 I gave them to have it back there?
No, Judge.
All right. All right, Deputy, you can go ahead and take that. Thank you. All right, and we are in recess until we hear back from the jury. Thank you.
Yeah, why not?
This is unrelated to the trial case. This is a different case. Thank you. All right, this is case 2025 CF 12120, State versus Jeremy Timmons. The court is going to announce that the next court date is July 17th, 2025, 9 o'clock in the morning for public defender docket sounding in front of Judge Kurt Jacobus. All right. And that's all we needed. Thank you very much. That was assisting with correcting a date. But we can be in recess until we hear back from the jury. All right, digital, this is Judge Musselman in courtroom 3A, and I told you that was it, but we do have some other matters that I need to make announcements on, completely unrelated to the jury trial. Thank you for putting us on record. All right, I'm going to start with case number 2024 CF 47498, State versus Laura Stark. The correct court date for Ms. Stark is July 17th, 9 o'clock in the morning for public defender docket sounding in front of Judge Kurt Jacobus. Also, case number 2024 CF 38088, and that is State versus Jerome Walker. And the correct court date should be July 17th, 9 o'clock in the morning for public defender docket sounding in front of Judge Kurt Jacobus. All right, that should conclude those matters. Thank you very much, Digital. We'll be in recess.
which is fine. I'm voting. I was totally saying. I was sitting in the newsroom doing nothing, and they told me to leave. So fine. Don't need to tell me twice.
I know.
there than people who live in. Exactly. How we get it. Yeah. But if you put the Taco Bell stuff on cardboard box, I'll be. And I was camping recently, and I had some steaks and something good. I could bring seasons in there, but I had a whole bag of various sauces, including Taco Bell sauce. Just contribute to the bag and say, yeah. Yeah. It's the little things about it. Yeah, that's right. This particular trip was at a place on the St. Johns River, you know where Osteen is? Okay, so there's a park, it's actually in Volusia County, called Hickory Bluff. You need a permit, it's right on the river right there is probably 100 yards wide. And, is it permit or predator? Yeah, there's like a pavilion and a house. The rest is just for site, and it's you want to, next time you go over there, without a permit, there's parking outside the walk through it. There's acres and acres of old four-wheels, big oaks. We have some, I put my tent out kind of like in the suburbs. But then I realized maybe 50 feet away from me there's a back box. They really circle and form around it. And I was getting a bit of that every now and then, and I get it. But super beautiful. I had a home boat and I bring it over to a place called Mullet Lake Park. And I put my boat in there, and it's about a 10 or 15-minute cruise up the river to the shores of Hickory Bluff. That's cool. Unload everything, and let's take it back. Never know if I'm coming. Yeah, I had a river diver. Loves camping. And really interesting. I don't know. I got 3 sons. 39, 41, and 43. We got 8 still got camping. Your sons can do it all for you. You don't have to carry anything. It's like, I got a camping united in 1983 Toyota Hilux. I like that truck. It gets me ready to travel again. Right. Right. Okay. I love camping. Yeah, I do too. We've, there's a group of us, my friends, we go to various places. A lot of our trips are by canoe. So like, one of the best places I've been is called Fish Eating Creek. It's, it starts kind of near, I had to go through Sebring to get to it. Okay, so it's in that area, and it's just like it's got some margins, and you just kind of cruise through, and it takes a couple of days to get through it. Cool. Well, This is a new area. It was recently opened. The lights go on, so across the whole lot, see it.
Living the dream.
Yeah, I do. I'm doing well.
So, for years and years, nobody could use it except for their family. Now it's open. It's super cool. We've been on Oklawaha River, East River. I've been across the river a couple times. Very cool. Yeah. Mine's talking to me about that right now. Mm-hmm. Mm-hmm. I live in South Purple Beach. Old house, it's a my drinking here. I have a fusion well. It's like 200 feet deep, sulfur water that's fresh enough to water plants. Mm-hmm. Yeah, it's all on the floor for a long time. Yeah. Yeah. So it's one of the things for sure. Yeah. Next time I go, I'll have to try to find my turkey. Okay, can we? Let's do it. Maybe I can. It won't be there if the chairs are fishing soon. We'll have to sit there. You should be sitting there. Take it easy.
Caesar, I just wanted to make sure nobody's that's worth more than I am.
Well, that's part of what Chief Lyle came out and was like, and now the FGLE is thinking, now the FGLE is thinking, so he was like telling about some interim stuff just to give people some kind of update. But that friend's recording this. A friend and they shared each other's locations on an iPhone. So where is the phone? Well, I found it with him in a parking lot across the street from the condo. So he's there. People had seen the car there, missing car. Now that car's gone, but he's there and he's got burns all over him. As gnarliness right there. Those are awful looking burns. Dude, you are just walking around town with skin hanging on. I mean, it was just really bad.
What was so weird to me, and this was just when Steve came out, is he was arrested by Rockledge police for a different thing, but with the woman who was stopping. He looks like treated. Like how much he aged. I don't know if it was the angle or just the stress of it. I don't know. It looked like a totally different person. It was wild. No, really.
I can't. There's. Unless it was just the cheese of food or something. Yeah, and I'm having an issue with our public works person is trying to figure this out because she's like, I was surprised. You know, the thing is basically secure video and stuff. You know, you can total count? No, he's like, yeah. Really? Because you play that stuff in open court all the time. I can understand releasing like school security video. I mean, there's exemptions for all of that kind of thing, but I don't know. So I'm leaving it to figure out.
No, seriously, it's like we're just so grateful. And the government stuff, I'm all the way on. And it's easy what you see. I'm coming in all the time.
Well,
So I was under
it helps gauge release and being part of like part is just because I honestly believe when you know this business, this is all done in open court. It should be there for all to see.
Right.
You know, but then the legislature keeps passing all these.
Right. Right, I know. Well, thanks for asking, at least whoever the clerk, custodian is, trying to figure out, you know, what
She
she
just spends her whole, spends every waking day immersed in all the things that prepare, because she fulfills all the requests that the attorneys.
Yeah, it was good.
No, there's still.
I was out there still with so many.
Like I said, if there's something that's really easy.
History was out of bread, today's out of chili.
Yeah.
It wasn't that food truck.
If you try to you respond as quick as you can, there's something I'm trying to do it makes it slow because it's just way more than I can do.
Yeah.
Well, here in Seminole County. Yeah.
So like the,
Last week we had a pretty significant murder trial. It's just a whole group of reporters. Yeah, and on Wednesday night I usually work over there.
you're not doing your evolution, the Xbox murder situation. That's covering that for days. Well, I guess weeks actually.
My daughter's covering that.
Oh, she is. Oh, okay.
She covers the week for 6.
Wait, Molly, that's your daughter? Oh, oh my goodness. And space.
Oh, yeah, she does that sometimes.
So I had like just started, and she was so sweet, super kind, and welcoming. And I was like, well, I'm not gonna see Molly because she's Volusia.
It's probably a good thing.
She had the wedding and then the baby. Yeah.
She's got plans.
I always think about it because it's a lot, and I know that she knows, and you know because you see it all, but it's awesome. It really is. Anything's possible. You just have to like change mindset or workflow or all that stuff.
Yeah, I was like, only about a year ago. What houses?
It's really fast for you. It's 1, 2, 3, all of the things, all of the adult decisions. Oh my gosh. So that's probably why you're like you support the like some stuff just falls through the cracks. Molly, she's sending all the requests.
Well, she's in the news business because I was for 25 years, and she grew up in the news in and around the Florida Bay, Palm Beach Coast newsroom.
So it runs in the whole family. So do you?
It's my chip off.
That's me. You know, when I was in college and I was like shadowing and having opportunities, all the reporters that I met, actually, it's doing journalism. The answer I always got was if I didn't make it right, they wouldn't do it. And I would sit there and be like, I am going into this field. You know, you are doing it for 30 years. You're supposed to be that. At least deserve me. Because I think it's amazing. Like if I had a child that people who why don't you do this? And I think the husband would be like, are you sure I'm seeing some stress? But I just think that it's awesome. And you don't hear about it too much, like reporter and
Yeah, I mean, I told her when you get a subpoena coming, she really wants. She loved it. She wanted to do it. Like, I would take her along. I would come and shadow me. And I used to go to News 6 to do like the weekend. I was like the smart newspaper guy on the political shows, you know, and so I'd do that, and they did like the last we partners with some space and just so I could get a cost back for space. And but so she went along with me, and there wasn't anger. She just loved Molly and just like grabbed her and like, I'm gonna give you a treat place. So she was like, wow.
and she's doing that.
And so she is.
That's amazing though.
She loves, and she loves having Molly out on campus where she can just be
Her own bubble.
the queen bee of a county, you know.
I think everyone who's out here in this county too feels the same way. You know what I mean? She's got like a space. So this is fabulous solution, fabulous. Yeah.
You know.
Yeah, you just, you know, you're not worrying about like housing, you know, all the different places. She's, like you said, she's in control of that beat.
Yeah.
And I think it is good.
You know, so, and it's interesting you said in Seminole County, it was harder for me to get a handle on who,
Oh yeah, because everyone can just like
because
hop in.
they just wait, exactly, a lot of people just can't sort of figuring out who
Kind of
most
consistently covers.
frequently does it, or at least who on the news does to reach out to, I think, but it took me a while. It's totally different, yeah. They just feel like part of Orlando.
Yeah. Yeah. Well, that's so cool though. Now, did she leave Florida for a bit?
Yeah, she went up here, 5 years in Ohio, so she went 3 years in Youngstown, Ohio was her first year. That stuff was really tough. And then she went 2 years in Dayton, which I love. I thought Dayton was pretty cool. And like that.
She wanted to come to Florida.
She wanted to get back here, so yeah.
She should be so proud too that she got to go home.
She
always
is.
becomes like the goal of like, hey, I'm gonna do these kids, I'm gonna try to go back home. So she went to do that. That's awesome.
Yeah, I think she really appreciates it.
And yeah, appreciates not having to be in the news every day. I have to go
or sometimes?
No, I have to go in for drone training.
Drone training?
Yeah, they want me to have people watching the
You can barely fly a drone in Brevard.
No, I can't even, yeah, I'm
I mean, so everything's restricted.
I know.
Okay, go ahead, do your training. And they
Hey,
tell
it's
you
not,
you
it's not
can't fly it.
my desire to be trained, and I'm not flying it, I have to be the one to observe the person flying it. I'm like, eyes on the,
Yeah.
on everything, I'm like,
Hey, my, when I was working at the school district, we had a photographer there who had a drone, and he used it a lot for things. And, I asked him once, you can file a plate
yeah.
for this stuff sometimes? He goes, no, every time I do. And I said, hey, he just got it down to a routine, he just knew how to do it. And he said, don't let that deter you, they can tell you no, but they're terrified, they just want to know who's where. You know, they want to know you're not a terrorist. You just let them know you're flying a drone. In our case, we're trying to film marching bands, you know, and school activities, or, you know, sometimes we loan them out to the facilities department, and like, go up there and check whether the roofs were in good shape after a hurricane.
Right. So was it hard for you when you transitioned from media into more of the public affairs?
Yeah, it was. I mean,
It was different.
Yeah. Till that string pops.
well, yes, the
Hey, what's up?
thing that was easiest was very.
No, at five,
And
at
also,
five.
most places produce their own story credit themselves too, so I like that. But
Just, call Ewan, he's downstairs, he's not in the courthouse, there is a pool camera,
crazy.
but we might need you.
5 school board members and a superintendent who
But
this is much
he's at the courthouse in Viera,
Anytime.
downstairs.
all politicians think that
That's
they're
where he is right
criticized for
now.
something, it's because somebody didn't communicate well someplace. And it's like, well, that's not my job.
Where are you
I'm
now?
supposed to be, like, by law, I'm supposed to.
Oh my
this-
gosh.
this-
Yeah, you ain't gonna be no
certain
help.
Parents.
You ain't gonna be no help.
They,
But if they
Now
really
you
want
probably
you here,
love watching
okay.
with the,
Oh, we'll
it's
find
always,
something. Okay, I see you soon. Bye.
like what happened with this?
oh, I know.
That's hilarious.
I'm like it. Leave me out of this, like,
It's always gonna help us out.
I,
I said, well, okay.
so,
I said, where you
I
at? He
love
said,
this
the station. That's in
part
Orlando. I
because
said,
I have one more guy that I really enjoy.
He seems like one
you
of
can't help me. Where did he come back?
Fully honest,
So,
Right.
still
it's just
zooming in, you guys.
transparency.
Enjoy that rush hour traffic.
And, you know, I take it, there's something comes along in it, well, just get it all out, or just be honest and get it out the door. Make it a one-day story, don't let it turn into an investigation. You know, the one,
Well, if that happens, what's the issue go?
Yeah.
But that's, so we'll still miss that too. Because it's 4 o'clock. It's 4 o'clock. We'll miss that too.
they was trying to see.
yeah.
We had another size one, last time.
Yeah.
Oh, right, yeah.
Let's see how they're gonna handle it. Public comment. Walking this down.
I gotta say, the
I need to see how you can do that.
climate right now,
Discuss that with someone, not show public comment too. I'm like,
not doing anything.
it feels like a violation.
Yes.
I'm like, it's just publicly, people are publicly saying, how do you calculate arbitrary saying not to show it? I don't understand that.
Well, I can imagine what's gonna make it right. So,
If you can move it, like, in our front, that was possible because look what happened when private well and like people.
And that's still happening. We're still having problems.
And when that immigration act came down, the first thing that went out on the notes, you need to understand first.
yeah, so I
You
said,
may have disagreements on it,
this is a public
take it out.
record. If you record this, this is what it
God
has.
says, not only do we have to
And
do
then
this,
Gene
but you will be removed from office and fined $1,000.
And they were calling it
but
citizens'
now,
council.
so, you know, I was just at like a barbecue, like in a friend's house, you know. But part of the issue is, it wasn't she used the name, it was that everybody above her was under pressure
Oh, for sure.
to stop that. And she was told not to. And then it just became that insubordination. You know what I mean? She was gonna keep doing it. And it's like, what do you do? And then it becomes a standoff. And that's what happened.
Well, now, it's like literally, I don't know if you felt like this, but
Yeah, so I saw BPS through
like the long
to like right into COVID, which was through all the school shooting hysteria, teachers strike kind of situation. Then we got to COVID and we shut down the schools and made it everybody and like how to switch to at home learning. But I got out of there before people were being like hauled out of meetings and handcuffs for not, you know, protesting
did.
masks and things like that.
Yeah. Probably a good time to exit. Because it has now, it's still pretty heated. And now they're cutting off the public comments. Like, they're literally not recording them. And if you don't speak about an agenda item, they can take you out because you have to speak on topic. So people are just really fired up. It's just, yeah.
They just don't want to be crazy.
I know.
You can't just make the rules that everybody says.
I know. Yeah. Oh my God. It's interesting for us to cover. But it's not a good look.
They just can't help themselves. They just can't. I mean, it's bad. So every week. No, Mel was there. He saw
Mel was there.
It was every week there was some teacher getting arrested for something stupid. You know, having an affair.
Oh God.
But, you know, you get a call from your principal. TV vans are here. You're like, huh? Boo! Scramble. You know, and so you have to stand out in the suit all day.
Yeah.
Talk to them. Explain.
Right.
You have a comment? Yes, I do.
Yeah.
Here you go talk.
Oh my God.
But we have cases coming up here now that I have to go and try to explain, talk, you know, give her a response.
Oh, you mean when you were with BPS?
Uh-huh.
No, we're talking about.
And it's taken years for some of them to
Wait,
get
what
their
was some of
trial.
that until probably before I got here? What was some of the upcoming trials?
Well, I mean, like one of them, I mean, these are like, we got one guy who was arrested at Bayside High School. He was like the golf, really was charismatic guy. He was the golf coach and the teacher. And he kind of seduced and had a sexual relationship with one of the students. They set him up and stunned him. And he got all this text information and all this kind of stuff. Girls now, gosh. She's probably like 24, 25 and like out of college. But she's gonna testify. I've never seen a charging sheet so long. Just look at it. 7 capital sexual batteries plus like the same number of reading cigarettes and things like that. He's like, I think people who know him are going to go to jail for that. You know, just,
What's his name? Okay. And you said it's
in July.
in July.
I only bring that up this time around. People that had.
Right. So he's pleading non guilty. Yeah.
I mean, this guy. And that was an extent of like, I saw this guy, I was like, he's not a guy that we've been.
You're like, why is this happening to me?
Oh no. He seems so nice, but one time I met him.
Literally. Literally.
Remain seated for practice session.
giving them a moment to look at something. So, you know. State, have you been able to locate what you would like to review? You still to read? No, that's fine. I just want to make sure you found it. All right, thank you. I believe that we deleted those. Let's see. But I believe that we deleted that word out of it. Right. And I told her to take out opposing and resisting because they only used obstructing. So.
Obstruction is synonymous with resist and oppose.
Okay.
And I believe the language that this piece uses is intended to, or did in fact hinder the officer in the performance of his legal duties.
All right. Do you have copies of? All right. You can provide it to defense. And Ms. Worthy, if you would go ahead and put the case on the record, please.
Yes, the case is State of Florida versus Legonski, 27 Southern 3rd, 794, through the Second District Court of Appeals.
No, that's fine.
The jury instructions don't include any type of element of intent. It's a general intent crime, so I think it would be misleading and an error to require the dirty language involving intent. So I believe that it would be, it could be intentionally hindered or also did in fact hinder.
All right. Do you want to respond to her?
You're not guilty of a crime if you accidentally hinder a police officer doing something. It's all about intent.
But it is a general intent crime, too. So,
So, you know, just like driving along, cop is behind you trying to pass you. He's trying to go someplace. If you don't get over fast enough, you have hindered his progress, but you haven't committed a crime. And I would remind the court that criminal law is all about intent.
all right, just give me a few moments. I'm finishing up reading.
And this case doesn't involve just words. It says the focus thus should be on whether the defendant's false statements were intended to hinder the police officer in the exercise of his duties, not on whether the defendant's ruse achieved the intended result.
Okay. All right. Anything else that y'all want to share or argue regarding this?
Just that, I guess as I said a moment ago, I believe that the facts in this case differ greatly from the facts that are present in the instant case. I think the state's purpose in proffering this case was to flesh out the meaning of the word obstruct, which this court held to be similar to hinder, if the jury is looking for a specific definition. But if the parties cannot agree on the definition, the state would request that we use the information that Your Honor provided.
Okay. So yeah, after reading the case, I agree that the scenarios in there are different than the facts in this, and I still have a concern that the standard jury instruction for resisting an officer without violence has been, I think I said, was adopted in '81 and been revised 4 times, and they still have not defined resist, obstruction, or oppose, or that has, for some reason, never been added to it. So, and my thought is at this juncture is to give them the instruction that they must use their common understanding of the word obstruction, and as well as the jury instructions.
Okay.
Well, let me go ahead and, to make the record clear, is there an objection from the defense of me doing that, as the state said they're okay with it? Is there any objection to that?
We do object to that, Your Honor.
Okay.
However, I understand your ruling, and I'm not trying to obstruct or oppose you.
Okay. For the record, can you just say, you've said a few things, so I want to make the record clear. What is it that you would like in lieu of the instruction the court intends to give?
On the case provided by the state, which is State v. Legnowski,
Yes.
27 Southern 3rd, 794. It talks about,
Can you direct me, like, either what page or where you are, paragraph-wise?
yeah, it's third page, bottom right corner.
Okay.
Legnowski's words were intended to hinder, prevent, or obstruct Deputy Darst's legal duties of serving process and taking Cotero into custody. So the definition, Legnowski's words were not mere verbal expressions challenging police action. Rather, on their face, they were intended to impede the officer. So the definition should be words or actions that are intended to impede the officer in the execution of his duties, according to this case, and that's what the defendant would like.
All right. I am going to proceed forward with what the court has suggested. I'm going to write it on here, and I will give the parties a moment to come up and look once I have it written. All right, the parties can come up just to view the response. All right, we will be in recess until we hear back from the jury. The parties approach, please. Giving you some extra. One more time, if you'd come up and review what the court has drafted based on our conversation and arguments. Hopefully you can read my handwriting. All right, thank you. All right, thank you, Deputy. All right, so the court's going to take a recess until we hear from the jury.
Jack. How are you? Yep. Hey. Can you hear me okay?
I'll do the 7 later.
Huh?
Finish the 7 later.
The law says they can't force her out. Okay. Okay. Thank you. Can I ask you guys something? Hey, just making sure you have the tag, my graphic in the tag. Thank you. Are you good with it? It says city councilor guilty or something, or pleads guilty, but it's Ruth Z's face, you know, it's a statement from the president. I mean, it should be Ruth Z's face, but like I just, you know. Okay. The law says they can't force her out yet, and she's refusing to leave. The law says they can't force her out yet, and she's refusing to leave. Well, the law says they can't force her out, not yet anyway, and right now, she's refusing to leave. Now, City Council President Ruth Z. Louis-Jean did call for Councilor Fernandez-Anderson to resign. And in a statement today, she referenced the state law saying, as we navigate this difficult moment, we must remain guided by the law and focused on ensuring stable and continuous representation for the residents of District 7. Now, under this state law, Fernandez-Anderson will be automatically removed once she is sentenced. Live at Boston City Hall, Sharman Sacchetti, WCVB News Center 5.
your verdict as to count one? Juror number 3, is this your verdict as to count one?
Yes.
Juror number 4, is this your verdict as to count one?
Yes.
Juror number 7, is this your verdict as to count one?
Yes.
Juror number 8, is this your verdict as to count one?
Yes.
Juror number 1, is this your verdict as to count two? Juror number 2, is this your verdict as to count two?
Yes.
Juror number 3, is this your verdict as to count two?
Yes.
Juror number 4, is this your verdict as to count two?
Yes.
Juror number 7, is this your verdict as to count two?
Yes.
And juror number 8, is this your verdict as to count two?
Yes.
All right, ladies and gentlemen, I wish to thank you for your time and your consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who simply are curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. All right, this time we'll go ahead if you have it back.
All right for the jury.
All right, everyone may be seated. All right, so having been found guilty by the jury of disorderly intoxication and resisting arrest without violence in case number 2025 MM 13006, the court does now find that you're guilty of the offense of disorderly intoxication and resisting without violence. And I am going to take a brief recess, but counsel, I will ask, is there any reason why we should not proceed with a sentence?
There's no reason, Your Honor. No legal reason.
Okay, all right. So what I will do, I'm going to take a brief recess, give the opportunity of the parties to consider the sentence that they would recommend to the court, and I will be back likely within 10 minutes. If anybody need any more time than 10 minutes, you need to, okay, all right. So I will try to be back before that, about that time, all right? All right, the court will be in recess for approximately 10 minutes.
we shouldn't give the light people breaks. Question, the libraries, is that during the verdict?
Yes, it's,
I don't know why they don't have that.
I have been quite a historical. No, it was. It was off my. They didn't see the signal?
No,
They
they
didn't see the signal?
didn't, they didn't see a signal. I think that's constitutional.
And we're still flaming away.
No, that's, I think it's.
Yes, I'll let you.
Is your station seeing the signal? I'm just wondering if it's just my station. I'm asking.
It's coming out. No, I can give you the card if you take it downstairs.
I just don't have time to turn around for 6, because I was gonna have the editors drop it on at 1.
Hey, just confirm my signal to my TV. You got it? Okay. Okay, cool. Very good. Thank you.
You might want to scroll back and just make sure you got the verdict and admission, but you guys get the signal now. Probably got it.
Someone from my shop.
It sounds like they got it.
You guys didn't get the verdict?
It just came out.
That's the line that's released you have
So we cannot confirm that we got it, which I don't think that we have. Okay. Yeah, I don't think we got it. There's some issue.
That's what it sounds like.
You guys didn't have it either? Yeah, we don't have it. Okay, thank you. I just wanted to, check.
All right, we'll try to rectify
Yeah,
that.
it dropped, the feed dropped out for some reason.
I will give the card and try to get it on my laptop now and try to solve it.
And then have everybody roll on it. That's a good
Do,
idea.
do that.
Yeah, yes, the judge had stepped down. And we're gonna
Ready
send
now?
Hang on.
One, two,
And everyone would be seated. All right, has the jury reached a verdict? The foreperson will please provide the verdict form to the deputy and bring it to the court for inspection. All right, it appears that the verdict forms are both in order and there's no apparent errors. And Deputy Clerk, if you would please publish the verdict.
In the County Court of the 18th Judicial Circuit in and for Brevard County, Florida, case number 05-2025 MM 013006AXXXBC, State of Florida plaintiff versus Carly Gale Anderson defendant. We, the jury, find as follows. As to Carly Gale Anderson for the charge of disorderly intoxication. The defendant, Carly Gale Anderson, is guilty of disorderly intoxication. So say we all, the 6th day of May, 2025, in Brevard County, signed foreperson. In the County Court of the 18th Judicial Circuit in and for Brevard County, Florida, case number 05-2025 MM 013006AXXXBC, State of Florida plaintiff versus Carly Gale Anderson defendant. We, the jury, find as follows. As to Carly Gale Anderson for the charge of resisting an officer without violence. The defendant, Carly Gale Anderson, is guilty of resisting an officer without violence. So say we all, the 6th day of May, 2025, in Brevard County, Florida, signed foreperson.
All right, does either party wish to have the jury polled? Okay. All right, so Madam Clerk, if you would poll the jury, please. For both counts also, please.
Juror number 1, is this your verdict as to count 1? Yes. Juror number 2, is this your verdict as to count 1? Juror number 3, is this your verdict as to count 1? Yes. Juror number 4, is this your verdict as to count 1? Yes. Juror number 7, is this your verdict?
Advocacy Center of Brevard and 50 hours of community service. And the state would defer to the court regarding any additional sanctions.
All right. The request to reserve as to the amount of cost of investigation. What is your intention with that? When would you think you would know what that would be?
My plan is to reach out to the police department. The cost of investigation affidavit that was provided is not itemized, so to speak, and based on the fact that there was kind of a dual investigation with a co-defendant, I'm not sure how much of that applies to Ms. Anderson and the investigation that went on with her case. So I just was going to reach out to the police department to see if they're able to break that down a little bit so that we can have a better understanding of a true reflection of the amount.
Okay.
Which I can work on.
Yeah, we can talk about that a little bit more. But all right, so defense, what is your position regarding sentencing?
Your Honor, Ms. Anderson has no prior criminal history whatsoever and has been a pillar of our community in Cocoa Beach. She's given a large chunk of her life to the education of children of Cocoa Beach. She had a bad night, a bad moment, and she got caught on body cam video. So I would suggest to you that, and I understand you're going to adjudicate her guilty, she's already lost her job from this particular event, and I would ask there be no fine. I don't think probation is really necessary. She's had no criminal offenses in her entire life up until now, and she cannot afford to pay a fine, and she could do community service hours, especially in the service of our children.
All right. All right, anything further?
No, Your Honor.
All right, if I could ask, Mr. Weaver, you advised the court that she has lost her job. Is she currently unemployed?
Yes.
Okay. And State, I would like to confirm with you, too, that you do not show any criminal history for Ms. Anderson.
I do not see any prior criminal convictions.
Okay, thank you. All right, the court hereby sentences the defendant. You may be seated, everyone may be seated. As follows. So on the disorderly intoxication, she will be adjudicated guilty and placed on 6 months of supervised probation. She will be ordered to pay court cost. She will be ordered to pay cost of investigation to the Cocoa Beach Police Department, and the court will reserve as to the amount. I am asking that the state work in the next 30 days to establish that amount. All right, the court is also ordering that she is not to consume or possess any alcoholic beverages or any illegal substances. I am also ordering 50 hours, that's 50 hours of community service. The court is going to order the $500 donation to the Children's Advocacy Center. However, I am going to give her up to a year to pay that, which would be outside of the probation that I have given in this disorderly intoxication count. All right, I am also going to order random testing of alcohol and illegal substances for the probation term on the disorderly intoxication. The community service hours that I've ordered will need to be at a nonprofit agency. All right, as to count 2, resisting without violence, the court is going to adjudicate you guilty. I am going to sentence you to 12 months of supervised probation, and you will be ordered to pay court costs. I am also going to order another 50 hours of community service. So it will be a total of 100, but 50 on each count. So the second set of 50 hours can be done on count 2 after the first ones are done. They can be done, if you're unemployed and not working right now, that can be done as quickly as you're able to do it. But you also can put them off to another time if that's needed. All right, are there any questions about, I think actually the simpler thing, since I'm going to give you 12 months, the simpler thing is the $500 Children Advocacy Center donation. I'm going to place that, I'm going to remove it from the disorderly intoxication and put it on the other count, which will give her the full 12 months to pay that. All right. Does she currently live here in Brevard County?
Yes, Your Honor.
All right. So what I am going to order is that she needs to report to the probation office tomorrow. The probation office is located in Rockledge, and we will be giving you that information. You will need to be there before 4 p.m. tomorrow. So you can go about 9 o'clock in the morning to 4 o'clock in the afternoon is the latest time that you can report. Is there any issue with Ms. Anderson reporting to probation by tomorrow at 4 o'clock?
No, Your Honor.
Okay. All right. In count 1, I've placed you on probation for 6 months. The due date for all of the items that I ordered is at 5 months. So that's when you have to complete everything. Count 2, I've placed you on probation for 12 months. The due date for all of the conditions will be at 11 months. Yeah, I'm about to say, yeah. The 2 probation sentences are going to run concurrent. All right, so does the state have anything further they would like to address regarding this?
No, Judge.
And defense, anything further?
Yes, Your Honor. I would like you to declare her indigent and appoint the public defender for appeal.
Okay. All right. We do have an affidavit. You want? They are asking that affidavits be filled out. So.
She has no income.
Okay, no income. And does she currently have any dependents that she is supporting financially?
She has a 16-year-old daughter.
Okay. That lives with her and she is supporting financially? Okay. All right, I can leave it, right? All right. Well, no, Deputy, I am going to have her fill it out. I know it's been the request of the Public Defender's Office that they have affidavits, and so since we have the opportunity, so Ms. Anderson, I'm going to have you fill out the affidavit, and when you're done, if you can give it to the deputy, we'll review it, and then I will appoint if you qualify. And while we're speaking about that, before you do that, I do want to let you know that you do have 30 days from today's date to appeal the sentence that you just received. And if you need an attorney, the court can consider appointing, which I'm going to be doing in a few moments. Parties may have seen this already, but I just want you to know that on the count 2, I did not order the no alcohol and no consumption. I did not order the random testing, so it will only be in place for the 6 months on count 1. Just want to make sure everybody followed that because I know I moved around a little bit. So.
And I assume the court would consider early termination at some point in time?
Well, when the court sentences someone, there is no determination at this time, but the court is not saying anything about that she can't be early terminated. So it could always be brought before the court at the appropriate time.
Okay.
But I am silent regarding that issue at this stage. Do you want to clarify anything? And Mr. Weaver, Deputy Clerk has advised me that Ms. Anderson does have a cash bond of $500. So monies owed to the court cost that it cannot be used for the children's advocacy donation. So monies for the court cost, it will be deducted from that.
Okay.
And that takes the clerk about 60 days. So in about 60 days' time, you'll know if there's anything left or if there's more that will need to be paid. Is the state requesting a date where we could address the cost of investigation in the future, or the defense, either one of you? Or do you want to communicate amongst yourself regarding?
If we could go ahead and set a hearing date, I guess 30 days out, and then if I can reach out to Mr. Weaver once I get some more information from the police department, and if we're able to come to an agreement on that amount, then I think we could cancel the hearing and just submit a stipulated order. Does that work?
Yes. All right, it does appear that the court does have exactly 30 days. On June 6th, at 9 o'clock in the morning, set the tentative hearing regarding the cost of investigation.
Judge, is that like a Friday, you think?
It is a Friday morning.
I'm going to be out of town.
Okay, all right. Are you here on the 5th? Or
What date?
The 5th of 6/5.
I'm leaving on the 5th.
Okay.
I'm going to a conference.
Okay.
On the 5th through that following Saturday. I'll be
Okay.
back after that.
The following Saturday, meaning the 14th of?
No, I'll
that length?
be back on
Okay,
6th or 7th,
all right.
one of those days. if you wanted to set it on the 5th, we could move it, I guess.
Well, I was just trying to do about 30 days. The following week is jury trial week for me, so I wouldn't really want to set it there, but it looks like, let's see. I know this is right before you're leaving, but I do have the afternoon of the 4th, but it wouldn't be until about 3:30 that afternoon.
That's the Wednesday?
That is a Wednesday.
Yeah.
Is that
I'm not
problematic?
I'm not here that day.
I'm sorry. I thought you said the 5th. All right. All right.
I could do it on the 3rd
Okay. Let me take a look at that.
in the afternoon.
No, I won't be able to do it in the afternoon. So, all right. So what I will do, I'm going to ask the state to reach out to my judicial assistant. I am not opposed to setting it even the following week. It was just, it's my jury trial week. I'm sure it's a short matter possibly. So,
Would it be best to, I guess, once I try to get some more information and get an amount, if you would like for me to reach out to defense counsel and see if it's going to be agreed upon and there's no issue with it, then we wouldn't need the hearing date, and then I guess if it's not, we can request a hearing date from there.
yeah, that would work fine.
Okay.
So,
Yep.
all right. So we're not selecting a date. Did you have an opportunity to look at the affidavit? All right. All right, so Ms. Anderson, I am going to appoint the public defender to represent you for purposes of appeal. Deputy, could we provide a public defender business card? I think there will be one on the podium right there to her, and
I'll be filing the notice of appeal, Judge, as is my responsibility.
okay,
And I'll be working with Ms. Anderson to transition the matter through the DD's office to move it up to Daytona Beach, which is where all their appeals are done.
appeals are done, right. All right, thank you for giving her helping her with the initial steps of this, and, all right. Is there any other matter that we need to address from either the state or the defense?
I don't think so.
No.
Okay. All right, that will conclude our jury trial of State versus Carly Gale Anderson. Thank you all.
Thank you.
Judge. May we be excused?
You may. Is she gonna wait for her paperwork? For the probation office? Yeah.
I guess so.
She can wait. She's processing it right now. She can wait outside though. She doesn't have to stay in here. Deputies don't mind bringing it to her outside. Okay. They'll bring it to her outside if she wants to stay out there.